were formed a quorum. Thank you. Thank you. Item 1 on the agenda, information papers issued since the last meeting. Mr. SIN Chung-kai, Dr. Wai-kwok, and Mr. Charles Mok requested a discussion on information technology, that is telecommunications engineering grade. At our meeting on the 8th of July, we already had a discussion. Yes, Mr. Mok. Thank you, Madam Chairman. First of all, I have to thank you because I'm not a member of the panel. Mr. SIN Chung-kai, Dr. Wai-kwok, and I sent you a letter on the telecommunications engineer grade. The administration has submitted a reply. I won't like to repeat the details. The original intention was that we were not asking for a discussion on the specifics of that grade. In our letter, we mentioned that overall speaking, for the professional grades, including engineers, how will they be handled in future? We're very worried that this will become a precedent, so there is an element of universality in this case. Although I'm not a member of this panel, in the next session, perhaps, we can discuss this issue, because we are worried that grades that require professional qualifications may be treated by the government in the same way. That is, professional qualifications will no longer be required. So, Madam Chairman, would you please consider that? Yes, we'll put on record that remark of Mr. Charles Mok. In this session, we have no time for another meeting. You can raise this again during the next session. Well, Madam Chairman, I think for the next session, I believe I'll still be a member. Today, I just want to register this issue with you first. All right, we'll place this on our agenda to see how the administration will respond. All right, item 2 on the agenda, conditioned hours of work and leave deduction arrangement for civil servants working 45 hours net per week in the Hospital Authority, the HA. We've received some paper which have already been distributed to you. The administration has also responded. Please now invite the officials from the Civil Service Bureau and the Department of Health, Dr. Cindy Lai, to take us through the paper. Good morning, Secretary. Yes, we have the doctor here also. Dr. Lai, welcome. Welcome, all of you. Perhaps the Secretary can take us through the paper first. Thank you, Madam Chairman. I would like to explain a few points to you. First of all, the Hospital Authority is an independent statutory body. Therefore, in terms of its management structure, operational autonomy, it has its own rules and regulations. Because of its targets of services, staff, needs, etc., they can formulate their own human resources measures, including working hours and leave. Civil servants working in the Hospital Authority will be deployed to duties according to the HA. Still, there are civil servants, so their salaries and conditions of service, including the conditioned hours of work, will continue to be protected and restricted by the civil service regulations. Civil servants in the HA as well as HA staff are put under different conditions of service. In the civil service, there's no standard conditioned hours of work, depending on the nature and need of the post involved. Different posts have, or grades have different conditioned hours of work. To ensure that all civil servants enjoy the same treatment and conditions of service, members of the same grade are put under the same system, including the conditioned hours of work per week. The HA had adopted certain changes in relation to support staff. Their working hours have been reduced. In our view, there's no ample reason for extending that change to the civil servants working in the HA. That will affect civil servants in the same grade but not in the HA, including those working within and without the Department of Health. So any change will affect the whole civil service. Therefore, in handling this case, we have to be very careful, considering the financial implications, operations, fairness, etc. No matter what, civil servants' hours of work can be studied under 3 prerequisites. That is, no impact on quality of service, no additional power, and cost neutrality. Then our department can consider suggestions. In the HA, for those colleagues working 45 hours net per week, we've already started a review on those 7,600 odd colleagues who are subject to the net working hours of 45 per week. Anyway, we have to do it across the board, that is, holistically. We cannot just work on a particular department, otherwise there may be unfairness. We've requested bureaus and departments to, in relation to the bureau, and in the 3rd quarter of this year, submit their preliminary assessment and suggestions to us. Another point is related to the detailed tasks. The Department of Health is discussing with the HA to ensure that civil servants working in the HA will not, because of this change, have increased workload. I understand that the discussion is still underway. Another point that I'd like to mention is about the leave deduction arrangements. Same with the principle that I just mentioned, leave deduction arrangements may affect other civil servants. The present practice is that for the whole civil service, we're adopting the same practice. We don't think it is necessary to follow the practice of the HA. Besides, if we change the leave deduction arrangements, theoretically more resources and manpower will be required. But the original intention of the 5-day work week is not to increase resources. So much for my introduction. Thank you, Secretary. 2 members would like to ask questions. Mr. Wai-kwok and Mr. Poon Siu-ping. 5 minutes each. Oh, yes. Mr. Tan Ka-Pew as well. 5 minutes each. And also Mr. Sin Chung-kai. Altogether 4 of them. Mr. Wong? Thank you, Madam Chairman. Madam Chairman, 2 trade unions have written to you and the panel on the HA's new measure, which is to start on the 1st of May this year. That is, the working hours will be changed from 45, excluding lunch per week, to 44 per week, such that there will be paid lunch hour or meal time. The HA staff, of course, welcome that. However, that change is not to be adopted across the board. About 600 civil servants will not be covered by this improvement measure. Therefore, 2 staff associations and trade unions have written in to express their strong views. They request the HA to adopt the change across the board. That is, in one HA, there shouldn't be 2 systems, or 2 systems of conditions of service, 2 systems for different staff members. They have the same work, but have different conditions of service. That will lead to huge division. And the civil servant staff members will feel being discriminated against, and the morale of the civil servants in the HA will be affected. As they say, they are all paid under the civil service. Why is it that they are not being given the same treatment? Is it that they are lower than the other staff members? Is it that their contribution is less? Is it that their contribution and value are not recognized? I just noted the introductory remarks of the Secretary. He said that the HA is an independent body which can handle its affairs independently. However, the HA is funded by public money. It is supported by the public coffers. Therefore, the government is the biggest user. I'm talking about the role of the government. The government is the biggest user in terms of medical and healthcare services. The government is the biggest user. The government also funds the HA. Now that in the HA, the same work attracts different conditions of service. Starting from the 1st of May, the 600 or so civil servants will be discriminated against. Will the government turn a blind eye to that? Will the government not restrict the HA in this practice? The government is taking care of civil servants. Those officials who are in charge should not let the HA do what it wants. I hope that the CSB will respond responsibly. Secretary, Madam Chairman, as I explained, basically the civil service colleagues working in the HA are covered by the CSRs. Therefore, their salaries, fringe benefits, etc., in the past few years, developments had not been the same as their counterparts in the HA. Sometimes the HA staff fared better, sometimes they fared better. Now, this is an issue left over from history. You see, when the HA was established, some civil servant colleagues would like to retain their civil servant status. So it is very difficult that their salaries have to follow the HA's requirements. Statutorily, the HA can manage its own personnel matters. Understand that in the past, there were also cases in which HA arrangements were not totally imposed on our civil servant colleagues working there. Of course, the circumstances may not be the same. How should we match them? The DH and the HA are discussing the matter to ensure that our civil servant colleagues working in the HA will not, because of the change in working hours of the HA staff, be affected in their work.
Chairman, can the Secretary tell me whether this treatment is discriminatory? They do not enjoy equal pay for equal work. Please tell me whether this is discrimination or not. Secretary, I won't say so, because the HA has employed different staff members that started their service in the HA at different times, and they are paid differently. I'd like to register my strong dissatisfaction. Mr. Pan Xiaoping. Thank you, Chairman, for putting this item on the agenda. So, civil servants working in the HA are not required to work the same conditions of hours as their HA counterparts. I understand that it was not the case before the 1st of May. We're told by the Secretary that the civil servants have been seconded from the civil service to the HA and therefore results in different conditioned hours of work. I have met with members of civil servants and subsidized organizations committee under the FLU and also HKCSSA, and according to them, there's some problem or difficulties in management because there are civil servants working in the HA. Now, because civil servants are seconded there, so some colleagues may have to work longer hours, and this has caused difficulties in management. Although the Secretary told us that there would be a review soon, I'd like to sort out a few issues with the Secretary today. Although HA is an independent statutory body, but it is funded by taxpayers' money. And before they changed that mechanism, did they discuss with the CSB or the Health and Food Bureau? Secondly, there are actually civil servants on the general pay scale working in the HA. I think there are about 500 of them. So according to the Secretary, they are waiting for the review of the net conditioned hours of work. And according to the Hong Kong CSSA, administratively speaking, you may not need to increase manpower resources before that issue is resolved. So for civil servants working in the HA, can you tackle the problem not so rigidly? Because civil service morale is affected. For instance, in the same kitchen of the HA, there may be 1 or 2 civil servants. However, their conditioned hours of work are longer, so they have a heavier workload. So please give us a specific answer, because the colleagues are really very unhappy. Secretary, thank you, Mr. Poon, for your question. I will invite Dr. Lai to answer the first 2 questions. And go back to the review. As I explained, we're now reviewing the conditioned hours of work of Mok 1 staff. Of course, there are also other grades working 45 net hours per week. They amount to about 20,000. So the administration must act cautiously. We can't say that because they are of the same. Well, if they are of the same grade, their conditioned hours of work must be the same across the board. The government's position is for our colleagues of the same grade, they have different conditioned hours of work from colleagues of the same grade working in other departments. So HA civil servants, they are still civil servants. So I just want to explain that we'll have to do it in phases. So Department of Health staff seconded to HA, and if they are Mod 1 staff, if we reduce their conditioned hours of work, then non-HA staff who are also Mod 1 staff not working in HA would have the same expectations, and therefore we have to be very careful. Dr. Lai. We understand that about 562 civil servants are working in supporting grades. Staff are affected, and there are about 18,000 in total in the civil service. So 500, 600 is only 3% of the total number of supporting grades staff members in the HA. So the deployment of work may be a bit complicated, but we understand that the HA has all along got arrangements for managing staff of different grades. So we believe HA will be able to overcome the inconvenience caused by the current arrangements. For colleagues working in the HA affected by this new arrangement have expressed their concerns, and the Department of Health has met with staff representatives to reflect their concerns to HA headquarters. According to HA headquarters, since the 1st of May, they've reduced the conditioned hours of work of its supporting grades staff. And numerous units in different hospitals involving over 10,000 staff members are involved, and they do take time to adjust to the new system. In principle, they hope that the quality of service will not be affected. Hospital in charge and their frontline managers We'll keep in view the current operation and also the workflow where necessary. Our work arrangements and our work roster might be adjusted. Where necessary, they may increase their strength to cope with the new arrangements, and they may need about 9 months for the new measures to be smoothly implemented. During the adjustment period, they hope that staff can be accommodating and be tolerant. So we've expressed civil service concerns, and according to HA, they will ensure that the new arrangements will not affect the workload or increase the workload of civil servants working in the HA, and HA headquarters have relayed this message to all 7 clusters, the HR personnel of all 7 clusters. So I think the secretary, or rather the secretary has chosen to keep his hands off, and that secondly, and that they would reflect their difficulties to the HA, which will overcome the difficulties. Actually, these difficulties are created by you, not by the HA. The labor sector really applaud the HA's initiative, and that is to introduce a 44 hours gross condition of hours per week. So you should have finished the good work they have started, but you haven't done that, and you ask HA to overcome the management difficulties created by you. What's more baffling is you sound as if the civil servants are none of your business. In fact, you have civil service responsibilities in the representatives in the HA. I think you only say the 44 hours of gross. Sorry, you have overrun. I think they will be. Give me the same answer. I've got only one question. So looking at the paper, the secretary will say that it is not his business and that a review is being done. I'd like to know what are you doing currently to help them to transit smoothly to 44 hours gross per week. Secretary, I will invite the Deputy Director to supplement. Now, our review is to transfer from our review is about transferring from 45 hours net to 45 hours gross. So we may not be able to achieve in one step what the HA has done. So we are talking about a review, a transit from 45 hours net to 45 hours gross per week. Deputy Director. Yes, we appreciate staff's sentiments, and they have told us when we met them. So we have relayed their concerns to the HA. We understand that HA is making arrangements in various aspects, and they have relayed the message to the in charge of the clusters. They will ensure that the new initiative will not increase the workload of civil servants working in the HA. And as for whether the Department of Health has been consulted, the Department of Health is part of the administration, and we follow CSB's position. And we understand that any change would affect both staff of DFH as well as that of the civil service. So we will go by the policies of CSB. The staff's views are very simple. So HA staff, they enjoy 1 hour of lunch. In theory, they don't have to work during that hour. Whereas civil servants seconded to HA, they only have half an hour of lunchtime. For the remaining 1/2, they have to be responsible for the whole ward, and they have to take up the extra workload resulting from the 1 hour work-free lunchtime enjoyed by HA staff. They're saying that, well, why can't 562 of us go back to the Department of Health to work? Will they enjoy that opportunity? Since you cannot overcome the work pressure they face in HA, can they be transferred back to the Department of Health? Deputy Director, this 562 civil servants in the 1990s or in 1991, they are in the HA because of the handover to HA. So for staff that can be incorporated or absorbed by other departments, they would have been absorbed by these departments already. So for those remaining, depending on the grades they are in and whether they are needed in the respective grades in the government. But that's over a year, or there's over a decade, and for those that would like that transfer should already been transferred. So that's the triggering point. Mr. Sin Chung-kai, if I'm wrong, please correct me. I think some senior civil servants working in DHA are entitled to pension benefits, so their fringe benefits are entirely different from that of their counterpart in DHA. Now, if HA pay and conditions of work is superior to that of the civil service, can these civil servants be allowed to switch to work for the HA instead of remaining in the civil service? Are they given that choice? Secretary. Dr. Lai can supplement later. I think Mr. Sin is correct. In the past few years, civil servants working in the HA enjoy the same fringe benefits as the counterpart in the government. They are still civil servants, although they work in the HA, so they're still entitled to pension benefits. Pay adjustment, they follow that of the civil service. Of course, HA always follows the pay adjustment of the HA, but HA is entitled not to do so. So will these civil servants working in the HA have the choice to return to the Department of Health or to switch to HA terms? I think they have to resign first and apply for HA jobs anew, because the option was exercised when the HA was established. Dr. Lai? Well, in the 1990s, when the HA was set up, we had the Hospital Services Department and the Department of Health, and some civil servants were given a transition period to decide whether they would like to switch to HA employment terms or to retain civil service terms. There was a transition period for about 2 to 3 years. I cannot remember correctly now, because the transition period is over. The mechanism no longer exists for civil servants to become HA staff. So if there are colleagues who would like to be employed under HA terms, they have to leave the civil service. That is, they have to retire first or resign first and then apply for HA jobs. Were there precedents in the past? Right, the contention is, or the cause of the contention is, perhaps HA staff enjoyed better conditioned hours of work than civil servants in the HA. I'd like to know whether there have been precedents in the past, or after the exercise in 1990. After the transition period is over, has there been any switch in terms? Because there was a transition period, and we believe about 18,000 staff members switched to HA terms. About 8,000 odd civil servants working in the HA have kept their civil service terms. After that period, has there been any switch? Well, I believe there might be, though I don't have the figures with me. Some colleagues might feel that it is better to serve under HA terms. And I'm sure there are examples, but I don't have the figures with me. Mr. Martin Liu, thank you. I vaguely remember that in the Hong Kong Accreditation and Certification Authority, which I have worked, there was also a similar exercise. Some, of course, civil servants were employed on civil service terms, and they were given an option to switch to new terms, but because civil service terms were more favorable, many of them have chosen to stay in the civil service. I'd like to know whether this secondment arrangement exists in many public organizations. I'd like to know whether all secondments are treated with the same mechanism. And I understand that some staff have returned to the civil service. Now, if they have opted for different terms in a statutory body, and if they return to the civil service, how do you deal with this differential conditions?
The third question is about the Hong Kong Chinese Civil Servants Association's query. They said that similar situations have happened in the past, and there have been special administrative arrangements to resolve the problems. So my question for the Secretary is, why can't we resort to administrative measures this time? Several questions, part of them I would defer to Dr. Lai to tackle. Firstly, do similar situations happen in other statutory bodies? There are two types of secondment, as far as I understand. The first is the secondment will last a certain period. And within the secondment period, the civil service servants will remain on the civil service terms. Now for HA, which is such a sizable organization, and part of its functions are really functions discharged by the Medical Services Department in the past. So this is a special kind of situation. As Dr. Lai said, that there was a transition period of 3 years. Civil servants could opt to remain on civil service term and choose to serve on HA terms. So for the latter group, they would not be entitled to pension. So we are all very clear that this is a one-off choice. Sorry, can I interrupt? So what you meant by exercising a choice, i.e. whether they chose to leave the civil servants system and chose to opt for HA terms. Yes, you are correct. They chose the HA terms in the end. For example, workers, grade 2, many of them in the civil servants are on MOD1 grades. And if they opted for HA terms, then they would be entitled to the HA terms. But of course, the HA is offering different terms than the civil service for these MOD1 grades. The HA may offer better terms in those days than what they are doing now. At that time, the HA should offer similar terms as civil service terms, or else people won't opt to join. The last question. If, say, an HA colleague would like to return to the civil servants, well, we have to look at what grades they are in. Say, if they resign from the HA and they choose to return to the civil service, they have to do it apply through open recruitment. And whether we would give them additional increment, we will have to look at his or her experience. And we will also look at whether the civil service has difficulty in recruiting such staff. If not, then an additional increment will not be given. Now, my question on the special arrangement, can't you do it by way of a special arrangement this time? Dr. Lai. Civil servants who opted to serve on HA terms in those days, they would be entitled or subject to HA terms. Now, if in those days they chose to retain their civil servant status, they would be subject to civil service terms. But then they work on a day-to-day basis in the HA, then their work arrangement will be made by the HA. Now, apart from the civil service terms, there are several aspects which will be retained: staff appraisal, promotion as prospects, and training, and so on. Apart from these few aspects, the work arrangement will be made by the HA itself. Now, whether we can implement special arrangement to allow these people to return to the civil service, if, of course, there are openings, then that can be done. Now, in the past 10 years or so, I think that was already done if there are such opportunities. But then if there were no such openings, then that couldn't be done. I must reiterate that they maintain the civil service status, and then as far as promotion and training is concerned, they would not be any different from HA colleagues or HA staff. We've got two more members to ask questions in the second round. Oh, I've received a motion from Mr. Tan Ka-pyo. I urge the government to implement the 44 gross conditioned hours of work per week in the civil service, and then to implement it as soon as possible for civil servants working in the HA. Any seconder? Deputy Chairman. To second. All right, we'll vote after two other members have raised questions in the second round, Mr. Wai-kwok and then Vice Chairman Mr. Poon Seow-ping. 3 minutes each, please, because we've got a very long agenda today. And I'm going to photocopy the motion to everyone. Mr. Wai-kwok, 3 minutes only. Thank you, Madam Chair. In the first round, my question went unanswered by the Secretary. He said that the 600-odd staff in HA is a problem for the HA. But then we don't have any representative from the HA here today. So, Madam Chair, I earnestly urge that this agenda item be included in the meeting for the panel, and we would ask a representative from the HA to join our meeting to address our concern on whether HA can implement administrative measures to tackle the problem. I would also like to invite representatives from Hong Kong Chinese Civil Servants Associations and other civil servants associations, and also representatives from the Federation of Hong Kong and Kowloon Labour Unions to join the meeting to express their views. As what Mr. Martin Liao said, the Chinese Civil Servants Association said that there were precedents of administrative arrangements being made to address similar problems. So if we have representatives from the HA and other civil servants associations here, I'm sure we will be able to map out a solution. It's better that way because now we are facing the situation that the CSB and the DH are saying that they don't have a way out. So I hope that Madam Chair, you can agree to my recommendation. My question for the CSB, you said you're going to do a review. Is there a time frame? Can you, before asking the HA to come over, can you first ask them whether they can make special administrative arrangements to address the problem? Secretary. Okay, my 2 points to answer Mr. Wong's questions. As what Dr. Lai said, that the DH is negotiating with HA on how to make the best arrangements for their staff. So during the summer vacation, we will give you a reply. As what I explained a moment ago, what's most important is that staff will not have an increased workload after this new arrangement. Now, as for the other work arrangements, it will be up to the DH to discuss further with the DH to discuss further with the HA. Well, indeed, there were examples of HA's recommendations being rejected by the government. So for this particular situation, we do have difficulties because its conditioned hours of work forms part and parcel of the employment terms of civil service, and the ramifications are huge. Now, as for the review on conditioned hours of work for MOD1 grades, we are asking the relevant colleagues to give me a report as soon as possible, i.e. changing the conditioned hours of work to 45 gross conditioned hours. Now, DH is one of the departments who do a review, as well as some other government departments are embarking on that route again also. Mr. Pan Xiaoping, the secretary has responded in length, but then the Chinese Civil Servants Association was telling us that they are the CSB and the HA are just trying to shortchange us. I share a similar view as Mr. Wai-kwok. The review is going to last till the end of this year. The DH said that HA does face difficulties in implementing this special arrangements because 500 odd staff members are serving on different conditioned hours of work. So would you be able, say, to sit down with the Chinese Civil Servants Associations on the possibility of implementing administrative arrangements to address the problem? Secretary? Well, actually, we are on constant dialogue with the Civil Servants Associations on conditioned hours of work. On colleagues working in DH, perhaps I will defer to Dr. Lai. We appreciate colleagues' concern. And within the DH, we do have a consultative framework. Colleagues working in HA have a mechanism to express their views to us, and when we have received such views, we are we would discuss with the HA. Now, the HA said that they need several months to fully implement these arrangement, and in the interim period, they would try to come up with the best arrangement on work schedule and roster and so on. They need an adjustment period. So we're trying to understand from them how they're going to do it, and we will express to them colleagues' concern. And we have also relayed to the management of the different clusters to ask them not to pose any adverse impact on civil servants working in HA because of this latest policy. Well, I think we have to deal with the motion tabled by Mr. Tan Ka-piu. I urge that the government fully implement the 44 gross conditioned hours per week, and to give priority to implementing such a policy among civil servants working in HA and DH. The nominator is Tan Ka-piu. Seconder is Pan Xiaoping. 4 votes. Objection? 1. Abstention? You and myself. So this non-binding motion was passed. I can't vote because I am not a member of this panel. But in the second round, I asked that a session be arranged for the HA staff to join our meetings in the next legislative year. Yes, I will do so. I've heard your views. Thank you very much. Mr. Liao? Well, it seems that you haven't given us a time to speak on the motion. Can I say something about this motion? I don't object to the content of this motion. I'm thinking that we need time to deliberate and think through the motion before we vote on it. So to me, I don't think it's fair because we haven't been given the time to really think through the motion. It's not that I object to the motion. Mr. Sin. Well, we support 44 gross conditioned hours of work. I think the CSB should conduct a comprehensive review on this front. But then for the same grade, if there are 2 different systems of conditioned hours of work, then that's not ideal. And for the same type of work, there are 2 systems of conditioned hours of work, then that's not good management at all. So I think we should look at the situation overall, more comprehensively, and it shouldn't be resolved just through emotion or by way of emotion. Well, I want to say something on this too. I share the same stance as Mr. Liao. There are different grades within the civil service, and different government departments have different systems of conditioned hours of work, so we can't adopt an across-the-board approach. Mr. Tam, sorry, speaker not coming through. 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 We can do more to help lessen the work hours of staff or civil service. I don't want to dispute all these points, but I think the civil servants working in HA should be given priority when we discuss this policy. Okay, in the interest of time, because we've got a long agenda, so let's move on to agenda item 3, policy of granting paid study leave to civil servants. We've got Mr. Tang and also Dr. Cindy Lai here. Mr. Tang, would you like to say a few words first? The government strives to provide training opportunities to civil servants to equip them with the necessary skills to provide the best quality service to the members of the public. So training is very important. So, of course, we would monitor the implementation of training policy among civil servants. We've got guidelines distributed to various bureaus and departments, including granting paid study leave. And the guidelines have set out clear guidance on this front. The major conditions are the training is required to confirm the officers to their existing rank, or the training is essential for the effective performance of existing duties, or the training is essential for promotion, or the training is useful for improving work efficiency. Now we have delegated the granting of study leave to heads of departments and bureaus. And that is mainly because the heads of departments and bureaus have a better grasp of the needs for training of civil service, and that type of arrangement has been implemented since 1994. Now, given such a large number of government departments, it would not be good in terms of efficiency if the central CSB is dealing with the training issues. So what's more important is that we are reminding department heads and bureau heads all the time under what conditions should they be granting paid study leave. Now, on the concern raised recently, we have looked into how to improve or enhance the guidelines. One is how to strengthen our guidelines, and the other is whether departments should seek a second opinion from their respective bureaus to grant study leave in special circumstances. We are consulting various government departments on such proposals. Administration, do you have anything to add? Thank you, Madam Chair. No, not for the time being. Mr. Wai-kwok would like to ask a question. Myself, Mr. Yip Kin Yun, Mr. Sin Chung-kai. Any others? 5 minutes. Mr. Wai-kwok first. Thank you, Madam Chair. This incident stems from the fact that the Director of Health has granted a 1-year paid study leave to Dr. Sarah Choi to work as a pupil for 1 year to train as a barrister, and involves a government expenditure of $1.6 million.
That became a controversy. Now the administration is saying that there would be a review. Improvements will be made in future. In future, another tier of enforcement will be added to the regime. That is the policy bureau level. However, consultation is yet to be conducted. Now, given this issue, I'd like to know for how long will you conduct the consultation before you can draw a conclusion? Or can you tell us today that you can draw a conclusion to guard against a recurrence of such controversies? In future, if huge public money is to be mobilized for such training programs, I think consultation within the administration is enough. So how long will your consultation take further? Secondly, the Department of Health is not a judicial or legal department? Can the judicial organs and the DOJ provide support to the Department of Health, so much so that the department had to send their own staff on training programs? Secretary, I'd like to thank Mr. Wong for his remarks. I'd like to defer to Dr. Lai for an elaboration, but we cannot assume that there are problems with this particular incident. Of course, we would like to enhance our guide, but whether or not the case itself involves problems, I'd defer to Dr. Lai. First of all, I have to spell out under what circumstances the respective policy bureaus need to be consulted. You see, every year we have quite many such applications. Should we set a duration for consultation with the respective policy bureaus, or should we confine such efforts to professional qualifications? I think we have to set the circumstances involved. Therefore, we have to discuss with policy bureaus. So we have to strike a balance. On the one hand, we need to enhance monitoring through policy bureaus. At the same time, we need to have efficiency. I think in the next few months, we'll be able to publish a new guide. I'd like to defer to Dr. Lai for the details involving the Department of Health. Madam Chairman, in the paper, we explain a lot about our role in law enforcement. There are a number of laws that the department has to enforce. Very often, we have to consult the DOJ to seek legal advice. We've been doing that for so many years. In fact, over 10 years ago, within the department, we already started to examine whether or not we need to set up a prosecution unit within the department. We have to enforce over 10 pieces of legislation in relation to drug treatment, registration of Western medicine, dangerous drugs, tobacco control, infectious diseases, treatment of diseases, etc. So we have to handle a number of laws. Our colleagues need to seek relevant legal advice. And very often on special cases, we had to consult the DOJ. We'll continue to do so in future. While seeking legal advice, for so many years, our colleagues discover that if they can enhance their legal knowledge, it would be helpful to their work. Therefore, for many years, for different ranks of our colleagues, we've arranged legal training. In this particular case involving this particular colleague, we're providing her with more training in legal knowledge in the hope that in our department we can have a colleague with professional knowledge in public health, such that in terms of law enforcement, when our frontliners encounter problems, that colleague can provide legal advice to other colleagues. When this colleague comes back to the department, she'll still be in public health stream. That will not replace our seeking legal advice from the DOJ. So in future, we'll still collaborate with the DOJ. Allow me to ask a follow-up question. The administration spent $1.6 million on this directorate colleague to receive training. I'd like to ask this. If after a few years this colleague gives up her job, will public money spent as well as training given be wasted? Is there any mechanism to ensure that money and effort spent on training her will allow her to play her role in the department? I'm speaking on behalf of public concerns. Would you please answer my question as to whether or not the money and effort spent is well spent? Dr. Lai, in vetting this colleague's application for full pay study leave, we followed the CSRs in relation to those aspects mentioned by the Secretary. How did we select this colleague? Since she is applying for a whole year's paid leave, she had to sign an undertaking that after receiving the training, she had to serve the government for no less than 3 years. We observed that requirement. When we vetted the application from the colleague, we understood from the colleague that she had legal knowledge. We also understood her ability and for how many years she could continue to serve us. She had served for over 20 years in the Department of Health. She had rich experience. For many, many years, she was responsible for legislation, legislative amendments, laws related to infectious diseases, legislative amendments to medication laws, medical equipment in future. She had also participated. And we understood that the wish of this colleague was to remain in the public health stream and make use of her legal knowledge to more efficiently and effectively work for the department in the provision of quality service to the public. Dr. Lai, your answer was absurd. You said your department enforced over 10 laws. The police enforced over 100 laws. Does it mean that the police had to subsidize 10 police officers to receive legal training? The police also provides legal training to its staff members. That does not mean that full pay leave had to be granted. You said that she had participated in all legislative work. So with this barrister in future for advisory, prosecution, opinion, etc. required, given by the DOJ, will that be double-checked by this barrister of your department? May I know whether there's any precedent? The incumbent Secretary for Security, Mr. Wai-kwok, completed all legal training, but he did not practice. He also has legal knowledge to handle human rights matters, etc. Mr. Stephen Lam, former Secretary for Constitutional and Mainland Affairs, also received legal training. Now, may I know whether there's any precedent of allowing a colleague to do pupillage as well? I defer to Dr. Lai. Of course, the HOG was responsible. Well, I'm only asking whether there's precedent. Do you have any record? Don't pass the bucket to another person so quickly. The HOG was responsible for vetting the application. The CSB does not have the particulars. Well, you can issue a memo to all departments to ask for the information. Well, we can give you 2 weeks to ask all departments whether full paid leave had been offered for pupillage. That's very easy. Dr. Lai, your answer was totally absurd. Chairman, allow me to supplement. Just now I explained that in terms of law enforcement, we have many pieces of legislation to enforce. In our day-to-day work, we continuously consult the DOJ to seek legal advice. There are different cases. For example, in terms of law enforcement, in terms of investigation, we have to decide whether or not to take up prosecution. At different stages, we seek advisories on prosecution or otherwise. And every year, the number of cases continue to rise. Well, I ask you, in future, whether or not this colleague would become your in-house lawyer such that DOJ replies would be double vetted by her in future. So you don't trust the DOJ? No, that's not what I'm saying. We're not saying that we'll use our in-house lawyer to replace the service of the DOJ. We don't have that intention. I was only saying that in our department we'll have an experienced colleague with practical experience to understand the particulars of cases concerned and how cases should be passed to the DOJ. And sometimes we need immediate advice. For example, in our investigation work and evidence collection work, colleagues, particularly frontline colleagues, may be subject to legal challenges. Immediately, this colleague from our department can offer advice. Then, in the course of investigation, we can be more effective. Take, for example, infectious diseases. Sorry, I have to interrupt. Legal knowledge is so important. So why is a practicing qualification so important? Why do you have to provide pupillage? In 3 years' time, she can practice. This colleague funded her own legal degree for, say, 5 to 6 years because she thought that in her work, if she could possess the knowledge, it would be better. So she financed her own degree. We observed that given her legal knowledge, it was very helpful to us. As for the pupillage this time, she did not apply on her own. The departmental management, the HOG, or the management of the department nominated her. At that time, we observed that if we can have a colleague with practical knowledge, just like a doctor after completing the MBBS degree in university for 5 years, without an internship, without practical experience, there's still something lacking. At that time, we considered that our department needed legal knowledge, and this colleague has studied for a law degree. So at that time, her supervisor nominated her for pupillage, such that afterwards she could more effectively assist our department in our work. Now, Secretary for the Civil Service, once you have this president, EPD, FEHD colleagues might have studied for a degree and would like to have practical knowledge. Will the government also subsidize the pupillage? Then in future, they might say that they had to get involved in lawsuits before they could gain experience and knowledge. Should they start from law clerk then? I agree that this is not a very common case. Is it your policy to nominate somebody to serve pupillage? First of all, we have to hand this case back to the department for it to judge whether or not there was a need in terms of the work of the department. In this particular case, in special cases, perhaps departments need to consult the policy bureaus concerned. If a professional colleague applies to study for another professional qualification, we cannot say that this is prohibited under the CSRs. But relatively speaking, this case is rather special. So apart from HOG's decision, should the respective policy bureaus be consulted? We'll go back and examine that. Mr. Ip Kin-yun. Madam Chairman, I think a lot of us doubt whether or not there is collusion in this transfer of interests. On record, only one person made the decision, and after that decision by one person, another person received huge benefits. Prima facie, this is a rather absurd incident. Just now, Dr. Lai said that it was the Director of Health who made a nomination. I'd like to ask this. Was it first that there was a policy and the nomination was later made, or the nomination was randomly and casually made? As for policy, is it that the Department of Health had established that one or a few more barristers should be nurtured? Then within the department, they decided to invite different colleagues to apply, telling them that the department had such an intention. Or simply there was a nomination with no previous policies and no invitation to other colleagues as well. I just want to know the process involved. Dr. Lai, would you please tell us, was there any private passing of benefits? And what about the particulars? Let me first say something about department-related training. Just now I said that we had a lot of law enforcement work to do as well as law-related work to do. That's why for many years we've provided legal training to different ranks of our colleagues. Doctors, pharmacists, science officers, etc., scientific officers, etc., have been covered. Apart from legislative regulation, there are other medical affairs that require legal knowledge, like complaints on medical misconduct, compensation, etc. So for many years, we've provided different training to different colleagues. Some were short-term training programs. Others involved secondment or observations with other departments, like the Customs and Excise Department provided 20-odd-day training programs to us. Well, I think we understand those circumstances. My question was whether or not the department had established a policy to nurture barristers within the department. We did not have a policy to nurture barristers. As I explained 10-odd years ago, in the decade of the year 2000, we discovered that we had to enhance the legal knowledge of our colleagues within the department. Different colleagues in different units need different training. We observed that this colleague for many years had participated in a great deal of legislative amendment exercises. She also handled legal medical matters, complaints, compensation cases, etc. She also self-financed her law degree. So the senior management of the department discovered that we could further nurture her by providing her with practical experience, such that in future she could handle various law-related tasks. We did not have a policy to nurture, say, how many barristers. How did we select this colleague? We learned that not many colleagues in our department possessed similar degrees. Some colleagues had studied relevant law programs, but only she had obtained a PCLL qualification after obtaining a law degree. So in the long run, she would have over 10 years more to stay with our department. Well,
so I think I can sum up in this way. First, there is the policy within the department to set up prosecutions unit, and then the nomination was done in this way. The director felt that among his subordinates, he identified this one to be groomed, and so there was no policy to train or to groom trained barristers to do this job. So it's a rather it's not really a policy-centered arrangement. Rather, it's targeted at individuals. Is that right? Deputy Director. No, this is not certainly the case. Appreciate that many people have concerns about this granting of paid study leave, feeling that there is a transfer of benefits for a particular staff. No, this colleague or the immediate supervisor of the staff and the director of protection of public health nominated her, feeling that her competence, her acquired qualifications, her experience, and her performance was such that she could be nominated to take part in privilege, to acquire experience in certain areas, and we required her to choose areas relevant to her work, for instance, judicial review cases, criminal cases, and personal injury cases, and also medical negligence, so on and so forth. These are areas related to our work. Please clarify. Some new information was provided. It was nominated, or the case was nominated by a director or superintendent. So please be more specific about this. Well, we had the concept or the idea to groom this colleague. A few senior colleagues in the Department of Health understood her background and had the similar idea. And then the nomination was made by her direct supervisor working in the who's the superintendent of protection of public health. And it was also supported by the then director. Was that Dr. Zhang? I'd like to know whether Dr. Choi, the colleague who is on leave, is on study leave. She's on study leave, and her rank would still be a deputy or assistant director. So was she chosen to succeed Dr. Zhang? Did she say that if she was not granted study leave, she should not come back to be promoted? No. Promotion will depend on the vacancies, and her work would be related to regulations regarding posting and promotion. We have rules to go by. We will not guarantee anything for that colleague. Of course, we feel that she is the person with the caliber we need before we choose her. We will not do such a thing without basis. Mr. SIN Chung-kai, I agree with you. I think the crux of the matter is 1 year paid study leave for privilege. So please do not explain the need for you to groom your staff so that they have legal knowledge. We do not challenge this. In fact, other than your department, there are other departments that require that have to take enforcement action, and they also need legal information to facilitate their work. No one challenged you that. The question is 1 year of paid study leave. I think the arrangement was really tailor-made. Our common sense is you have such a policy well announced beforehand. Now, if you spend your own money to complete a PCLL, you will be granted paid study leave for a year. Now, if you have that promulgated policy, people will move towards that target. But the situation now is different. You nominate somebody to take that paid study leave without any formal announcement, then I think even colleagues in the police have to enforce relevant laws and regulations, and the same goes for many government departments. The Civil Aviation Department, for instance, have the Civil Aviation legislation, EPD, environmental protection legislation. Well, I'd like to know whether all government departments will follow the practice of the DFH. Will all departments have their own prosecution division? And how can you work with the DFJ? Can all departments take the role of DFJ? I think that in this case, the Department of Health has made up its own policy. Can that be applied across the board? In the civil service, it is for the CSB to comment. Can CSB accept this as a general policy for all government departments? For instance, should the police or other government departments responsible enforcement ask for similar arrangement, such as the customs and excise, police, and even the immigration department? Well, many of them have to enforce laws and regulations. Will the CSB accept similar arrangements and will grant a year of full paid study leave for their officers? Secretary, do you agree to this policy to send somebody on privilege to see how judges deal with judicial reviews? First, the position or the role of DFJ. Of course, the DFJ is the main legal advisor of the government, and their place cannot be taken by any other government departments. And many departments have the in-house solicitors or lawyers seconded from DOJ to work for them. And Chairman, as you mentioned, there are departments who send colleagues to receive legal training. This has always been the case. Oh, I beg your pardon. I'd like to know whether in-house lawyers of departments are seconded from DFJ. Some of them are. Some departments have these arrangements. Of course, as explained by Dr. Lai, it's not just about enforcement. They have to study and research into new regulations. So after receiving training, the colleague would not just be responsible for enforcement. They have or she has to research or study new legislation. There is no policy that says specifically whether this can or cannot be done. There may be special circumstances to be decided by the department concerned, and the Bureau has to agree or has to decide whether that special training is essential for the work of the department and whether meets the requirement of the work of the department. The Secretary has not answered my question whether this policy can be applied in other departments. To answer Mr. Sin simply, it is for individual departments to prove the need. We will not say definitely whether it can or cannot be applied in other departments. We will not say we encourage this. It depends on the needs of individual departments. In other words, do you feel that the Department of Health does have that need and you agree to that need? Mr. Sin's point, yes. Of course, there's a need arising from the work of the department. The CSB doesn't deal with the frontline needs of departments. We can only regulate using our established mechanism. And I understand that the Department of Health has consulted the Food and Health Bureau. I don't think Mr. Sin is very happy with your answer, but that can't be helped. I give the floor to Mr. Leung. Well, this is just a mess. First, I don't agree that this is a nomination. It's a recommendation because there were no procedures to follow. There was only one staff member concerned. How many assistants assistant directors know the director. And I think you only talk about facilitation of enforcement. There are many double degree graduates and lawyers who are out of job. Why don't you employ them directly to work for you? Because you are looking for somebody with the administrative ability, not a doctor. You can advertise. Do you really want to recruit somebody? Do you want to recruit a lawyer? There are many lawyers available out there. And thirdly, you tell us you just want to facilitate your enforcement, gathering of evidence and to decide whether a case should be prosecuted. Ultimately, you have to defer to the Department of DFJ. So you ask a deputy director, you grant her 1 year full pay study leave, and then after 3 years of service in your department, she can go into private practice. Well, I see you shaking your head. Maybe you say that that's not the case. Well, you have to understand. There is conflict of interest here. If you cannot give us full explanation, this is conflict of interest. Well, I investigated Mr. Siam Leung's case. It was very simple. I asked for all emails to be passed to us. And then we saw that Chen Ka-shun can walk directly into Siam Leung's office, whereas I couldn't do so. I would be arrested protesting outside his office. So Mr. Cheng could have direct access to Siam Leung. So if you want to be vindicated or seek redress, show us everything. Yes, LegCo has no power to do anything, any good things, but we have the power to investigate into your conduct. I think you're even more naughty than my goddaughter. So you show us all the documents, relevant documents. There is nothing confidential about it. Now, if you think that your policy is right, after your defense here, it would become a legitimate policy. If you say that what the Department of Health has done is correct, it will become a policy. You don't have to bow your heads. You should be able to tell us strictly that you have established a good system for Hong Kong government. You pay somebody to acquire professional qualifications so that in future they'll be able to get the evidence and prosecute cases. If that's the case, then it can be applied to all departments. You are creating a precedent. You ask us not to make sweeping statements, but why don't you show us all the documents? Perhaps the person said that, well, I didn't have enough sleep during the period, so I made a mistake. That's okay. So first of all, tell us, have you told us everything? What about the emails concerned? I think the whole thing is really a mess. The head of the department claimed that she was qualified, and according to what you said just now, there are very few persons with the qualifications. So are you trying to make savings for the department? Chairman, I formally ask you to ask Mr. Paul Tang to submit all the email correspondences right from the beginning, if they have not deleted them already. I repeat once again, all the correspondences and emails right from the beginning. Of course, phone calls cannot be tracked, but I think this is fair. Show us all the emails and correspondences. If you don't do this so, then don't think justice can be done. Mr. Leung, I myself has drafted a motion I read out to you. This panel urges the CSB to seriously investigate the approval by the Department of Health for Dr. Choi Wai-yi to take 1 year paid study leave. And should there be any maladministration, there should be the appropriate sanction and remedial action to be taken. All right, I will have it photocopy to everyone, and I think we can decide after everyone has asked questions. Well, I don't really want an investigation. I just want all the documents. When we probed into CM Leung's case, we were shown all the emails. Day one, starting from day one, his negotiation with Representative Chiang Kai-shek and how Land's Department backed down. I want CSB to investigate. It has the responsibility. It check all the emails concerned and show us the result. It's just for your reference. All right, it doesn't matter. Mr. Martin Liu, we have a barrister here. Well, having heard the Deputy Director's explanation, I share your view. It's all nonsense. I didn't intend to speak, but I was thinking that, well, they committed a mistake this time. Okay, please don't repeat it. There's no need for me to labor the point. But having heard her explanation, I find some problems, and I must say something about it. If civil servants want to enhance their knowledge, it's something to be encouraged. But for legal knowledge, it might be useful, but not necessary.
In fact, all government departments are monitored by different laws and regulations. So should it be the case that every department should send someone to train as a barrister? Not only that, Madam Chair, every department has a training budget each year. And is it the case that they should send someone every year to train as an economist or as an accountant? I think this is totally illogical. Secondly, getting admitted and also serving as a pupil. And actually, the purpose of these two exercises is really to get admitted to the bar. Now, if you want to get knowledge, you don't have to get admitted. And you take an exam just because you want to be admitted, and that's the sole purpose. The director said that Dr. Sarah Choi will not replace the role of DOJ, so she won't represent the DOJ in a court. So I think this is all very superfluous, especially the pupillage. That's exactly because I want to express my worry, because the secretary said that there will be a review, but after having heard what the director said, she said that what they did is right. So what's the use of conducting a review? I don't want to get into debating with the director. I want to pose this question to the secretary. I am just worried that the review won't serve any purpose. Well, Mr. Liao mentioned 2 points. The review is on the system and not so much on the recommendations or on training. In the system, apart from the department head for special circumstances, the department might have to seek consent from the relevant policy bureaus. Second point, whether the review would serve any purpose at all. I think all recommendations for training have to be decided by the department themselves, as I explained before. Apart from enforcing the law, the Department of Health has also have to pay attention to international health laws and so on. So these are all matters for the department. So in some special circumstances, the Policy Bureau has to give a view. But for the CSB, our role is to ensure that in the system there is a second tier of approval. And whether the training will serve its purpose will be within the jurisdictional decision of the relevant department. I think all the Secretary said is nonsense. Mr. Martinello, you still have half a minute. Well, the question is very simple. Secretary, do you agree that the department sends someone to train as a barrister, as a pupil? As simple as that. Well, Madam Chair, I have answered your question. From the CSB's perspective, we will say definitely yes or no. I think we have to look at the cases on an individual basis, and the relevant department has to come up with full justifications, sometimes with the approval of the relevant policy bureau as well. Well, I'm going to give up, Mr. Liao. Dr. K.K. Kwok, I'm not a member of the panel, but then I still want to raise a question with the administration. I think you are doing a bad thing with good intentions here. This is a typical example. I'm sure that the Dr. Choi is a very competent staff member. That's what I heard from the department, colleagues from that department. But that's not the most important point. I think it has to do with the system. I know that every department has some sort of prosecution duties. So it's impossible for us to ask each department to send someone to train for a special profession like a barrister. Now, if we have to get legal advice, then we can turn to the DOJ. Is it true that the DOJ has not been providing a professional enough service to the DH so that the DH has to train its own staff on legal matters? Now, if that is the case, then that is very serious problem. If that is the case, the DOJ may have to come to this panel to explain why they are providing such poor services which don't meet the requirements of the DH. Well, it's very difficult for us to accept that every department will send some colleagues to train as a barrister. Well, I think the matter doesn't have anything to do with Dr. Lai. I think it has to do with the former head of the department. Now, for this particular case, the then Director of Health, did he seek the consent, or did he inform the Secretary for Civil Service on the matter? Well, I agree with the Madam Chair that we should launch investigation, but for this particular case, I would like to know in the civil service, are there any other past examples where a civil service is granted paid study leave to train as some professionals? Well, even if you are studying for PCLL, it's just still confined within the knowledge level. But then if you serve as a pupil, then you may be admitted in the future. So Dr. Choi, the colleague in question, does she have the intention to be admitted to the bar and practice in the future? Now, if there aren't sufficient legal officers in relevant departments, should we create new posts in the DOJ to address the matter? Now, on your question about professional knowledge training, other departments other than the DH may have to deal with legal matters And the DOJ will be giving a hand to these departments in most of the cases. But as what I explained, or what Dr. Lai explained, some of the cases have to do not only with enforcement of laws, but rather it involves some legal knowledge in order to deal with the matters better. Well, some of these matters might not be taken to the DOJ for advice. So for this particular case, this colleague can have knowledge on both medical and legal affairs after training. Now, for this particular case, the department heads is authorized to make the approval. So this case has not gone through the CSB. So are there any other examples within the civil service where full paid study leave are granted to civil servants? Now, as I said, we've devolved the authority to the department heads, so we don't have these statistics or figures in this regard. Well, let me add a few points. Dr. Kwok said about the service of DOJ is not that they are not providing a good enough service. We are all the time seeking legal advice from the DOJ. For seeking advice from the DOJ, we have to provide each and every detail of our case, especially from the perspective of public health. So if we have a colleague who has both legal knowledge and public health knowledge, then we would be able to discharge a better job as far as public health legal issues are concerned. We're just trying to do a more efficient job. And very often we would be able to provide timely advice to our colleagues. Say if our colleague collects evidence on site, he may need a very quick advice legally. So if we have a staff internally who can provide such advice, then that would make things easier for us. And we don't have to turn to the DOJ all the time, and which may cause delays. So does Dr. Choi plan to practice? No answer to that. Well, as far as I understand, Dr. Choi intends to remain a doctor in public health, and through gaining legal knowledge, she will be able to discharge her functions or duties more effectively. All right, in the interest of time, Mr. Tam Yu-chung and then Dr. Leung Ka-lau, I'll draw a line here, and then second round is myself and Mr. Martin Liao. Madam Chair. I think the devolvement of authority, this system is too lax. According to the present arrangement, we can say that it's all right because this doctor does have a need. Now, why does this case raise so much controversy? Well, normally we find it appropriate if the training is very related to the work duties. But then for this particular case, it seems that it's going too far. Training as a barrister. Would this give people the impression that Dr. Choi will turn to become a barrister in the future and not a doctor? So these kinds of queries would arise. Of course, we know that she would not replace the service rendered by DOJ. For every law enforcement body, whether a particular case will be, whether there will be prosecution taken out of a particular case, will be the judgment of the DOJ. I do admit that if a doctor gains a legal knowledge, there are benefits. I agree with that. But then if she is training as a pupil, I think that's superfluous. I am not sure whether an investigation into the matter will achieve any purpose at all. I think we should look more at how to review the present arrangement to ensure that there are clear guidelines, and not it's just that the department head has the authority to make such approval. Such approval should be granted by a higher level of authority. I think that's more appropriate. You don't need them to respond to you, right? Yes. All right, Dr. Leung Kalau. Next. I don't know whether Dr. Choi has offended many people. I've worked in the HA for so many years. Whenever a doctor has worked for 4 to 5 years, he or she will be sent out to training for, say, half a year or a year on full pay. And what's most important is that the training is related to his or her service. So what we demand of the DH is to give some examples of doctors requiring legal knowledge in their work. What is the efficiency of the DH in dealing with legal medical matters? Say, if you can show us that there are many matters which you have to deal with requiring DOJ's support, and then you can show us that a staff trained in that regard will help a lot, then that would be good. But then if you are saying that there are once or twice at 1 or 2 occasions in which you need DOJ's support on certain medical legal matters, then that would not be good enough. So do give us some specific examples on how this training is related to the duties and functions of the DH. Some barristers told us that pupillage is not essential. It's just for taking an examination and getting admitted to the bar. That's what I was told. I'm not in the legal profession. So if that is the case, I think the pupillage system is problematic. The experience is not important. It only serves as a purpose of enabling the pupil to take the exam and get admitted. So if that is not the case, then it will serve no purpose at all. I think Dr. Choi has risen to a senior level within the DH. She is an assistant director. Unless she encounters great difficulties in her work in the DH, it is very unlikely that she would start all over again and start as a very junior barrister and enter the bar profession. Any who to respond? The department head will grant approval to paid study leave. The CSB doesn't have any information on other government departments sending colleagues or staff members to serve as pupils. I'm sure the police sent their staff members to train in the legal knowledge. Do you have any information on whether they're allowed to serve as pupils as well? Well, perhaps we'll go back and take a look and give you the information later. Now, all government departments need legal knowledge, and give us some information on whether any government department sends their staff to serve as pupils. I don't know whether Dr. Choi has offended other people, but I know that many civil servants are dissatisfied, are very angry about this incident, and some barristers also complained to us because they don't allow for so-called double professionals. I've received this complaint letter. This barrister wrote to the Special Committee on Pupillage and Limited Practice of the Bar Association. And it says clearly that non-legal professionals applying to serve as pupils have to get the approval of this special committee. They are not allowed to be double professionals. So this particular professional who wrote this letter was refused in his application to serve as a pupil. And this letter says that you belong to a different profession, so you are not allowed to serve as pupil. So this professional was so very angry. So it's not fair. Dr. Lau. I don't know how Bar Association considers individual cases. Dr. Choi who serves as a pupil now, may be considered as, say, serving the doctor mainly, and then her barrister's capacity is also subsidiary in nature. So my case is different from what Dr. Choi's case. Now, the case that you mentioned may be that the profession still maintained his profession as his main profession, and then the barrister as a subsidiary profession. Now, I don't know what Dr. Choi has in her mind, but if she remains as a doctor in Maine and then sort of serves as a barrister as a subsidiary profession, then that's allowed. I'll read you our letter. Any pupils who wish to engage in subsidiary profession must obtain the approval and apply for a pupil who serves as a pupillage during leave or access may be considered as taking up supplementary pupillage. But approval of a pupil master and the special committee is required. The DH has also given us a reply that Dr. Choi has several barristers who serve as masters. And the special committee has not given her a reply, and the Bar Association is going to follow up on that. So in other words, the Bar Association doesn't easily grant applications for double professionals. Some people are refused such rights, and they are very angry. So we have to treat everyone fairly, and we have to treat everyone fairly. It's not that people are particularly harsh on Dr. Choi. I think we just have to be fair on everyone. So that's what I want to say.
We have a motion in front of us. This panel urges the Civil Service Bureau to seriously review the pupillage decision in relation to Dr. Stella Choi of the Department of Health, so as to clarify the relevant policies and procedures, and if there's any misadministration detected, reprimand and other appropriate remedial measures should be considered and adopted. Any seconder? Mr. Poon? I don't have any more to say on this. Does any other member want to speak on this motion? Those in favor, please raise their hands. 3 colleagues. Those against, please raise their hands. No? I also agree. But of course, as chairman, I would not raise my hand. So 3 in favor, no objection. The motion is carried. Let's move on to the next item on the agenda. Policy of granting paid study leave policy of the government in the calculation of salaries of government school teachers. An old issue. 3 deputations will attend. They've already submitted their written submissions to us. Please invite them to come in.
入緊嚟啊，入緊嚟。團體嘅名，喺呢度我呢度抄翻先。係，我哋多謝三。
We'd like to thank the 3 deputations that are attending. Does the administration have anything to say in terms of introduction? Madam Chairman, as you said, this issue has been discussed a number of times in this panel, so I won't repeat the details, but I'd like to reiterate 3 points. First of all, government schools and aided schools belong to the same teaching profession and are paid on the same pay scales. But they belong to 2 different systems, so the operation and management of the 2 systems are slightly different. For government schools, their teachers, their salaries and conditions of service are not identical with those of their counterparts in aided schools, so we cannot compare the 2. In 1999 and 2006 starting salary surveys, the differences already existed. Government school teachers are civil servants and are regulated by the civil service regulations. Their salaries and conditions of service are covered by the CSRs and the rules and regulations promulgated by the CSB. All along, such policies have been implemented consistently. We do not believe there's any maladministration. Although government schools adopted such policies, there's not been any misconduct or maladministration, so nobody should have sustained loss in terms of salaries and conditions of service. Secondly, technically there are details in relation to salaries and conditions of service which varied with time. For example, in the year 2000 and also before the year 2000, the 2 batches of civil servants enjoyed different welfare or fringe benefits, so we cannot carry out a simple comparison between the 2 types of teachers. Thirdly, we understand that some teachers deemed it unfair to have differentials in salaries after the latest exercise. However, we would like to have a consistent policy adopted for teachers of government schools and aided schools. We have 3 participating deputations today. I'd like to remind them that they're not protected by the Electoral Powers and Privileges Ordinance. Speaking time per deputation is 4 minutes. If necessary, you can wear your earpiece and choose the channels. Channel 0, floor. Channel 1, Cantonese. Channel 2, English. First deputation, Mr. Chung-kai from 政府教育人員職工會. Good morning, Chairman and members. In July 1999, the CSB presented to the LegCo a paper on the salaries of aided and subvented organizations should not be better than the civil service packages. In paper 31, struck the year 2000, it's said that in the subvented sector, the salaries should not exceed those in the civil service. Therefore, in terms of implementation, some problems had emerged. Between 2000 to 2003, there's evidence to indicate that the teachers of aided schools had actually been higher than the salaries of government school teachers. That is a truth. Take, for example, working experience for ICE arrangements, the present salary arrangements, recognized experience to be served as an element of consideration had led to loopholes. That is, sometimes the aided school sector had a higher pay than the civil service. We find it difficult to understand the response from the CSB. In August 2011, in reply to this panel, paragraph 4 of that paper says that they would like to reiterate that the principle is that the subvented sector should compare with the civil service, and teachers of the aided schools should not enjoy higher salaries than those in the government schools. In that paragraph of the reply, there are flaws, two of which. First of all, the CSB assumed that the conditions of service of the civil service should be served as a basis of comparison. That's only an assumption and was erroneous. Problems had emerged. Now, the second problem was that teachers of government schools could only compare themselves. However, if there are flaws, it is meaningless to have internal comparison. So 1 plus 1 equals 2. Even if you do it 100 times, 1 plus 1 still equals 2. So an internal comparison would not reveal the flaws, and therefore it is unfair to teachers in government schools. In that reply, it is also said that it did not mean that when teachers of government schools are more preferential, it does not mean that the same conditions of service would be applied to teachers of the aided schools. Therefore, the administration was of the opinion that there's no reason to compensate or remedy teachers of government schools. Now, some problems have emerged. Whether or not the salaries and conditions of service of government school teachers are better, the principle was not applied to the determination of the salaries and conditions of service of government school teachers. Our aspiration and request are very simple. We ask LegCo members to seriously consider the determination of salaries and conditions of service of government school teachers and inspect the various irregularities related to the matter and make proposals to the CSB timely. Next, Mr. Wang Han-kam, Vice Chairman of Union of Government School Teachers. Thank you, Chairman. Thank you, honorable members. Concerning the salaries of government school teachers, starting from the year 2000, we've been following up on the issue. Some teachers had contacted us. It's only in 2003 that we started to have the Education Bureau to replace the Education Department. A person approached us, and that teacher was unable to reach the senior level of the administration. Therefore, in the course of our discussions, he was only able to reach up to the level of Principal Assistant Secretary. That's why this person approached us for help. The phenomenon is that some government school teachers with more experience were less paid than those with less experience. Secondly, some government school teachers with the same number of years of service were paid less than their counterparts in aided schools. Given given these salary differentials, we've all along been assisting this colleague or colleagues to strive for fairness. Given the structure of government schools, we clearly understand that we should enjoy increments for recognized academic qualifications. But then in the middle, there should be this so-called healthy transfer. For the increments involved, we have to emphasize that their experience should be respected. Now, what problems have emerged? Let's look at the minutes of the last meeting. The salary changes, there were 3 changes effected respectively in 2001, 2007, and 2011. The pay structure had not been changed for the civil service as a whole, but we experienced 3 changes. For the 2007 exercise, we read the 2006 papers for entry pay, and we clearly observed that the approach was a lenient one for subvented organizations. For the civil service, we have to abide by the CSRs. So there are 2 systems. As the Secretary said, there are 2 systems, and calculations were different for the 2. Therefore, in terms of spirit, it's actually against the pay rise spirit. As a result, administrative measures were confusing. In the past decade, there had been more adjustments to entry pay points. We understand that government school teachers are civil servants and are regulated by CSRs. But in the education sector, most schools are in the public sector. But 2 types of teachers receive different treatment. That's why civil service teachers are so angry. I'd like to leave some time to Ms. Wong Hung Lin to elaborate. Ms. Wong? Thank you, Chairman. Honorable members, we heard Mr. Tang, the Secretary, just now. His reply was unable to address our concerns. According to this paper in hand, that is CSB PG 4 085001-299C. There it is clearly said that this healthy transfer policy will not be extended to other groups of grades. That is, among the 260-odd grades in the civil service, only civil servant teachers were covered. In 1999, the administration did not consistently implement this healthy transfer policy. For pay policies, we emphasized a healthy transfer policy is to actively encourage teachers to teach in different schools. Under that policy, there's a specific requirement. That is, we must not cause teachers to enjoy worse conditions of service or pay because of the transfer. And there should be a differentiation between government schools and aided schools. On page 1 of our submission to you today, that is spelled out very clearly. In 2001, for the transfer policy, the policy was changed. In 2007, it was changed. May I refer you to page 2 of our submission? In 1999 and in 2007, there were 2 different versions. In the 1999 version, there's a second requirement. There shouldn't be any differentiation as a result of the transfer. That was deleted from the 2007 version, thus changing the policy content. That is tantamount to changing the policy. should the government go through procedures in effecting that change. This transfer policy is related to the benefits of civil servants. They did not come to the panel on public service, or they did not consult relevant organizations. So the government should not unilaterally change this healthy transfer policy. We did inquire with the CSB for the details. May I refer you to page 3 of our submission. The administration's reply is that the Education Bureau and the CSB did not know the details of the change. Why is it that the administration does not know the details of changes effected by itself? So the answer was one of an uncertain one. So we're very angry. We deem that absurd. Civil servants should insist on the rule of law, be clean and fair and just. Senior officials of the Education Bureau, should you have high-quality conduct and swiftly implement the healthy transfer policy, in the past, omissions in the implementation of the policy, you should be held responsible. All frontline civil service teachers should be treated fairly. Otherwise, the reputation of the government might be tarnished.
I will pause here for the to facilitate further discussions. Thank you. Thank you. Mr. Tang, hang on. We still have one more deputation. From the Education Employees General Union, Ms. Yu Yiwa. Thank you, and good morning, members of the Council. This issue has dragged on for 13 years and still not resolved. This is because the CSB has been dodging the issue. For instance, when we asked the CSB, what's the color of this apple I'm holding, CSB will very seriously say that, well, an orange is orange in color. And I asked them, what's the color of this apple I'm holding? And the CSB will spend 15 minutes to tell us the details of history of an apple and come to the conclusion that bananas are yellow. So the CSB has been dodging the issue simply because it knows that it is wrong. Well, they have been using a specious argument to bully civil service state teachers. So we're very angry. I urge members of the council to use reason and to use our wisdom to vindicate government or civil servant teachers that have been silent all along. In the interest of time, I'll pause here. Thank you. Thank you, Ms. Yu. Right, Mr. Ip Kin Yun, Mr. Lang Kwok Hong, Mr. Tan Ka Piu, and Mr. Tam Yu Chong. 4. I'll draw a line after that. Any response from you first, Mr. Tang? No more favorable. The policy of no more favorable. Well, we've explained in the past that this is the principle we do not say that when the pay of aided schools is better than that of government schools, we will certainly improve the latter. Well, this is not the case. It's just a guideline. It doesn't mean that we have to follow the pay of aided schools if it is more favorable than that offered by government schools. And healthy the healthy turnover policy is to ensure that individual teachers would not lose as a result of the turnover. But that doesn't mean that aided schools and government schools must have the same employment package. We have not changed this policy all along. Right, that's it, Secretary. I give the floor to members. Mr. Yip Kim Yin first. Thank you, Madam Chair. Well, the past few pay adjustment exercises have caused a lot of trouble for aided schools and government schools, the calculation of pay and also the damage to teachers' morale. Some teachers, after suffering for a few years, came to find out that his pay or the pay is very similar to new recruits, and therefore it appears that their seniority or experience is not treasured at all, and they have been bothered by that. And as for salary differential within government schools, well, I think it's obvious, and we have discussed that many times in this panel. Although I am a new legislator, I've checked record, and there have been a few discussions on this. At the last meeting, a motion was passed, and this panel urges the administration to review the remuneration and conditions of service of teachers in government schools and to compensate teachers for their loss. So there's a motion passed by this panel. So I'd like to ask whether the administration has really responded to this motion. I said, we don't believe there is any maladministration or anything wrong, so we have no intention to change the situation. We're very grateful to the deputations for coming to this meeting. Can the deputations please comment on the government's response? So feel free to let us know your views. Anyone from the deputations? Mr. Yong? Thank you, Madam Chair. The CSB insists that it has done nothing wrong, but we can use real cases to show you that in 1999, under the healthy turnover policy has never been implemented because there are two requirements under the policy, but one of them has never been implemented. And then in 2009, there was no prior consultation with stakeholders prior to the change of the policy. The policy was changed unilaterally, and this is unacceptable. So, Mr. Tang, being the head of the civil service, please give us a direct response. When I ask you about the color of this apple, please don't tell me the bananas are yellow. Any response from the deputations? Mr. Zheng, please. I think Mr. Yip has put it very correctly. We just ask the administration to act according to the motion passed by this panel. And why did the Secretary said that there was not such a need? The administration assumed that there was nothing wrong with the policy. I think this is very close to a reasoned political issue, assuming the administration claimed that consultation was already done and that it was correct. We don't know what is the outcome of the review, so why don't you get on with the review and we'll see whether the administration is right or wrong. Okay, that's what we're asking for. Let's see if you still have some time left. I think we have discussed this issue for a long time, and the issues are very clear. Perhaps there is lack of communication between the government and the relevant unions. Should there be a review of this matter? And the motion passed by this panel should be given a detailed or comprehensive reply from the administration. So this is a request from Mr. Yip. I'll give the floor to Mr. Leung Kwok-hong first. Mr. Leung. I think the whole thing is very straightforward. In 2007, they unilaterally changed the policy without consulting the LegCo. So, because they felt that it was none of our business. So what's the point of asking the government to heed our motion? We've been told that it was none of our business. So we're here to monitor the government. And there are different stakeholders here. We monitor you, and you tell us that we are really not relevant. So, Mr. Given that they've already decided that it's none of our business, why do you insist? This is unimaginable. You have established procedures, right? If a policy has affected stakeholders, or if it's change of a policy will affect stakeholders, how can you proceed without consulting the stakeholders? Or you're saying that we're all correct? What's the point of consulting? Now, please don't address us as honorable legislators in front of the administration officials with no power at all. We're asking for review only. Are you going to do that to cover a few areas in your review? First, whether, as a result of your change in policy in 2007, or even before that, there were some laws on the part of stakeholders. You're not willing to do the review. You're not going to give us a full account of the matter. So what are we going to do? We have two items on the agenda. First, to give full paid study leave to an assistant director. No explanation. Right, to frontline teachers, you're so bureaucratic, and then for your assistant director, you allowed her to acquire professional qualification without paying anything herself. How can that be? All right, assuming they were wrong. Secretary, are you going to conduct a review or not? You have to answer this question, because it can be the basis of a judicial review. If your policy is correct, is wrong, and you refuse to review it, then that will be the basis of a judicial review. I give a chance to answer my question. Can you really compensate for their loss? Why in 2007 you didn't consult the stakeholders as well as LegCo? 6 years down the road, stakeholders and LegCo asked why you're not willing to conduct a review in accordance with the motion passed by the panel. Now, if you're wrong in the past and you insist on your mistake, then you have to be held accountable. Secretary, we can't see any maladministration on our part, so we don't see any basis for us to overturn our previous decision. No, in 2007, you overturned your decision made in 1999. And you insist that your change in 2007 was correct, and you don't want to change it, and that there is no maladministration. Is that what you mean? In 1999. All right. Is there any way to compensate for the loss of income arising from your change of policy? I think this is a legitimate expectation. Well, our healthy turnover policy has ensured that colleagues would not suffer on a personal level. Regarding the differential pay between government schools and aided schools, well, the two cannot be directly compared. But your policy is to ensure that even if the switches between government schools and aided schools, there won't be no personal loss to the teachers. And you're saying that, well, there is a pay differential between two types of schools anyway, and it's stupid for you to have changed schools. That is just like you board a minibus, claiming that the terminus will be at a certain location and suddenly it's changed. I have no more to ask if that's your answer. There is no alternative but to seek a judicial review or to call a strike. All right. I guarantee that I won't kill you by stabbing you, but what if you died after that? Mr. Tan Ka-pil? Of course, it is for the teachers to decide whether they will go into litigation. I think teachers are asking for arbitration, a means that is not so costly to resolve the matter. And I believe the proposal has been turned down by the administration. I'd like to know the reasons for that. And can the administration give us a clear response? The pay differential between government schools and aided schools, do you admit that this is the truth? Salary differential between government schools and aided schools. Arbitration. We believe we have implemented our policy, as I have explained a number of times. I think this should not be about comparison between government schools and aided schools. The healthy turnover policy has already provided safeguards for income of the teachers concerned. The second question, I perhaps will invite Mrs. Hong to supplement. Mrs. Hong, thank you. Speakers off mic. All right, civil servant teachers and teachers in aided schools. As the secretary said, the two types of teachers are employed under different systems or regulations. So, of course, there will be difference. Civil service teachers are subject to CSR. So we have to work in accordance with the CSR. Under CSRs, we have pay increment system according to experience of teachers. That's always been the case. So teachers are employed under different systems. So of course, the conditions of employment would be a bit different. So there cannot be any direct comparison between the two. I'd like to ask whether government teachers' schools earn less compared with their counterpart in an aided school of the same seniority or years of experience. Well, they are paid according to the same pay salary, but of course, depending on the time of appointment, there can be different regulations. So teachers have their remuneration determined according to the rules or regulations enforced when they are appointed. So you're saying that government schools will offer lower pay, so you should not join government schools. So sooner or later, all government schools can be closed. Now you say it's difficult to employ teachers, and the fact is, government schools offer lower pay to teachers, and you're encouraging teachers to teach in aided schools. Well, salary is only part of the conditions of employment. I think there are various aspects, including stability, medical and healthcare protection. Well, there's a series of factors. We cannot just consider salary alone. Any response from deputations? There is still time left. EBD and CSB, I think their argument is very spacious. The healthy turnover policy has two requirements. First, to ensure that the teacher would not suffer any income loss as a result of the switch. So there is protection on a personal level. But what about the second policy requirement? There should be a distinction as to whether they are going to government school or an aided school. So according to the reply by the administration, there is a distinction. So this policy is breached. We've been asking for this. We've been asking this for a long time. Why is it that without going through due procedures and consultation, the policy has been changed? Perhaps legislators only know today that the second requirement or the second leg of the policy is already gone. We have to look at what's in the letter of the policy. For instance, there are two legs in the original policy and one is already gone. So the spirit of the policy is not already here. Is not here. So CSB and EDB have turned a blind eye or have totally ignored government policy, and they can even change government policies arbitrarily. If this is to be a precedent, I don't know how the administration is going to deal with such cases in the future. How come they could bypass LegCo and undermine one very important role of LegCo, and that is to monitor the executive. Thank you.
Mr. Tam Yu Chung, next, please. Ms. Wong made a strong accusation, and I hope that the government can respond to that. Has the policy been changed? Has something been deleted? And so on. Can the administration respond to it? All right, I'll defer to Ms. Cho. Thank you, Madam Chair. I want to make one clarification. In the 2006 starting salary review, after that, the administration submitted a paper to the LegCo, and in that paper, in paragraph 19 to 22, the administration spelled out clearly the special arrangements for government school teachers after the 2006 starting salary review, and that applied to both government school teachers and aided school teachers. And I want to clarify that we haven't changed any policy after the 2006 starting salary review. About the ICE and the package, the differential between government schools and aided schools, and that doesn't stem from the starting salary review. And that has to do with the two different systems of the government schools and the aided schools. And it has nothing to do with the starting salary review. I want to make this very clear. We haven't arbitrarily deleted or changed the policy. The distinction has all along been there. Of course, in the paper we submitted in 2007, we didn't copy word by word the paragraphs, similar paragraphs from the paper in 2010. But then the policies remain the same. Ms. Wong, Hanglin, do you accept this explanation? Government officials from CSB and EDB should know better than I do that the policies provide guidance. Any determination of pay scale should be based on the policies. Ms. Choi talked about this paper. It talks about determination of pay scale, and there are different ways of doing it. But all these are based on the healthy turnover policy. The explanation given just now is utterly nonsense. You are trying to compare an apple with an orange. Here, what you talked about is just one way of determining the pay scale, and it doesn't have anything to do with the healthy turnover policy. I think you have changed the healthy turnover policy arbitrarily and behind closed doors. Now, under that policy, you must draw up the pay scale strictly based on the healthy turnover policy. You have met with the first requirement, but for the second requirement, i.e. not to draw a distinction among transfer between schools, be they aided schools or government schools, I think you are not abiding by that. You are really drawing a distinction. Here, you are drawing a distinction while you are not allowed to do so. And you should have already, or you should also conduct a consultation with the relevant stakeholders and related organizations. I think there is a serious problem here. And I don't think the LegCo should turn a blind eye to this. Well, time's up. Well, can I follow up one more point? Well, we still have one more agenda item where 13 deputations will come to present their views. All right, second round, Mr. Yip Kin Yuen, Tan Ka-piu, and Mr. Tam, 3 of you. 3 minutes. Please, because 13 deputations are waiting for the next agenda item. Mr. Yip. Well, we talk about comparison between apple and an orange. I think that reflects accurately the situation we're facing here. Can we compare whether the Earth is bigger or the Sun is bigger? They are of two different systems. There is no way of comparing them. Can we compare pay in the private sector or public sector? No way. So according to the logic that we just mentioned, there shouldn't be a comparison made because it involves a lot of complicated factors. The government official has tried to skirt the question raised by Mr. Tan Ka-piu. Now, for the whole matter, it has to do with the pay of government school teachers and aided school teachers, and also the government school teachers who are more experienced than those who have less experienced. Now, for the comparison between government school teachers and aided school teachers, you were telling us that there is no comparison can be made. Well, if that is the case, there's no use of us discussing the matter anymore. But I think we should come to some conclusion as to whether a comparison can really be made. I think we need a clear answer on this. I'm not saying that we should say one way or another, but I hope that the administration can give us a clear answer. Whether there is the situation where the pay in aided schools is higher than government schools. All right, I'll tackle the question first, and I'll ask my colleague to supplement later. All right, our principle is this. I don't think there should be uniform conditions of employment between government schools and aided schools. Pay is important, but that's not the sole factor. But for government schools, the administration will look at whether there should be a review if we have difficulties in recruiting people. But such a review will depend on the prevailing situation. We won't do it just because we have to catch up with the pay of the aided schools. That is not a justification for the review, and that is not a policy objective. Now, you said that you are worried that people may not be transferred or join government schools. That has to do with our recruitment policy. If there is a problem there, we'll try to look at it and tackle it. All right, anything to supplement from our colleagues? I want to talk about healthy turnover of teachers, and that is just for the teacher profession, the healthy turnover policy. And the carry forward arrangement ensures that teachers moving between government schools and aided schools will not suffer a loss in their pay level. And that's the objective behind such an arrangement. And if at a particular point the teacher believes that she is suffering, then, well, she or he may choose not to transfer. And that healthy turnover policy applies only to the teaching profession and not to other civil service grades. So even if after there is deduction of a salary, after the review, that aided school teachers can still maintain their pay level when they move over to government schools. So that's really to encourage healthy turnover of teachers. At that particular point, the teacher will not suffer a cut in pay. But then situation may change, and there are different conditions applying to different periods. And the healthy turnover policy's objective is not tackle those situations. It just ensures that the teachers are protected at the point when they are being transferred. Madam Chair or Mr. Tang? I don't want to see the situation where the education workers are coming to meet us every July to air their grievances, once in 2011 and this time in 2013. They've raised their concerns for so long, and these concerns are not given due respect or consideration by the administration. Well, let's cast aside who is right in the right or wrong. Let's see if a review can be made. Secretary, you said that pay is not the main element in the conditions of employment, but that's not the case in the teachers' minds. Well, in the long term, the pay is going to affect the government schools recruiting teachers. Secondly, the teachers believe that their interests have been harmed. Now, considering these two elements alone, well, I think that warrant a review. I don't want to see another discussion here at the LegCo. Can you undertake to conduct a review and to provide a platform for fair discussion among all parties? Secretary? Well, members expressed a worry that teachers may not be attracted to serve in government schools. I think the EDB has a better grasp of the employment situation, and if the problems are identified, of course they're going to tackle it. Now, we mentioned about the healthy turnover of teachers' principals and no better than principal, and I don't see that we need to conduct a review because I think these principles are well in place. Anything to supplement from you, Mrs. Hong? Perhaps I'll say something on recruitment of teachers in government schools. In 2010 and 2011, we conducted two open recruitment exercises. Some 3,000 to 4,000 applicants lodged applications, and we are subject to CSR in our recruitment. And based on the ICE policy, that can only be granted under the CSR that we have difficulties in recruiting teachers. So under that regulation, we can't grant ICE. I think that differs a lot from the aided schools because aided schools have more flexibility. They can use the bylaws to grant ICE, so they are subject to different systems and regulations, hence the differential salary and employment terms. For the civil servants, we have medical staff benefit and MPF, and that also differs from that offered by aided schools. Mr. Tam, anything from you further? Yes, perhaps I'll invite Ms. Wong to say something about this. The government official said that the teacher would not suffer a pay reduction at the particular point when he is transferred among schools. Well, do you understand the matter differently from what the EDP said? Well, I think the arguments of EDB are flawed. Well, as far as the first requirement is concerned, they are doing a good job. At the personal, individual level, they are doing a good job. But for the second requirement, i.e. not to draw a distinction between aided schools or government schools, they have not met that. I am in a fit-in situation from 20.24 to 25. But for aided schools, if I am transferred as a GM, and if this teacher shares the same qualifications and years of experience as myself, he will be entitled to 0.31, 6 points higher than myself. So that runs against the rule that you should not draw a distinction between aided schools or government schools. Well, the question is simple as that. And these are very senior government officials sitting here today. No one can address my concern, and no one can answer me. I've made inquiries with many government departments, many government officials, and I was given the reply that an apple is not an orange. So this is a line rehearsed by the government over and over again today as well. And you also try to divert our attention by saying something about the figures of applicants in your recruitment exercise and so on. So please, let's focus on the crux of the matter today, and that is you are not fully implementing the healthy turnover policy, and you refuse to admit your mistake, and you refuse to admit that there is maladministration, and you are not meeting the expectations of the subordinates of the teachers who have high expectations on their superiors. I want to cry here. I'm so saddened. And this is internal wastage and attrition of our efforts. And this is also meaningless. Secretary, why is there such a big differential? Any justification or explanation from the administration? Mrs. Hong, please. Thank you. I just want to repeat what I said just now. For the healthy turnover policy, the teacher who is going to be transferred should make comparison between what he enjoys before and after the transfer. So this is our policy. Well, that's all I can say. And we are implementing it. Well, thank you for attending the meeting. The agenda is very long today. We still have 17 deputations and individuals who are here to give us their views on the next agenda item. I'm afraid that we have to end the discussion of this item here. The next item is on the employment of persons with disabilities in the civil service. Originally, we have scheduled for a break, but we are running short of time, so we will not take a formal break. But if you want to be excused for a while, please feel free to do so. As long as we have the quota here, then we can still continue with the meeting. So now let's invite the deputations and the individuals to come in.
我唔去咧 X 個 lunch 噶，你話俾佢知 public service panel overrun 都好緊要，今日嚟唔到。OK， 唔該，點樣話？
我哋咧就先同啲團體講話，佢哋有3分鐘。咁如果3分鐘係20個團體咧，即係話
60分鐘，一個鐘。
咁啊冇時間討論㗎啦，因為我哋定咗1點鐘完嘅。
咁啊褪多15分得唔得？
得。
咪加多15分咯，加多15分咯，好嘛？
咁就要控制嗰度，唔好俾佢哋過時。
得好。我唔去得行會食晏㗎啦，你去美心買個飯盒啦，我中意食嗰隻咧，1點有骨到，擺上嚟，唔使飲嘢㗎，唔使飲嘢，唔該。係，唔該，各位都坐定啦嚇。
I believe you have all been seated. Thank you for coming. At the same time, I'd like to apologize for keeping you waiting for so long, because just now we had a heated debate. Due to time constraints, I'll accord each deputation 3 minutes. Originally, our meeting was scheduled to end at 1 p.m. If members so agree, I'll extend that to 1:15 p.m. so as to allow the administration to respond. I'd like to remind the deputations that they're not protected by the Electoral Powers and Privileges Ordinance. If necessary, you can use your earpiece. Channel 0 is floor, Channel 1 is Cantonese, and Channel 2 is English. First deputation, Hong Kong Federation of the Blind, Mr. Ng Kai Lun. Thank you, Chairman. The unemployment problem of persons with disabilities, that is PWDs, is very serious at the moment. I'd like the administration to announce in the past 10 financial years the number of new recruits in the civil service, the number of PWDs recruited, and the number of PWDs during recruitment or when recruited, and the number of civil servants who became PWDs in the course of their employment. The administration must make public for bureaus and departments the number of civil servants and employees employed and the number or proportion of PWDs employed, such that we know the employment situation of PWDs in the government, such that society can employ more PWDs. At the moment, the 10 top bureaus or departments with the highest number of PWDs do not record a high number of PWDs. Number 3, FSD, number 5, HD, and number 8, Customs, number 9, Customs and Excise Department, as well as the number 8 department are not within the top 10. The government must attain its 2% target employment rate for PWDs. That is, PWDs who have declared their disabilities at the time of recruitment, only they should be included. And it is the basic responsibility of the government to recruit PWDs in the civil service, and that's a pledge to society. Besides, the government should require subvented bodies to announce and update their target employment rate for PWDs so as to implement the policy of recruiting more PWDs. Subvented organizations should gradually adapt to that target of employing PWDs. Finally, in order to employ PWDs so that they can fully play their roles and abilities, the administration should proactively in government departments and various posts conduct analysis. The government, for example, should study the working environment in the government so that PWDs can be redeployed among government departments and bureaus. Thank you, Mr. Ng Kai Lun from Hong Kong Federation of the Blind. Next, Mr. Wai-kwok, represented. Next, the Hong Kong Association of the Deaf. Association assist the hearing impaired, provide them with counseling, provide them with more opportunities and job opportunities. We also set a good example by employing people with hearing impairment. However, we believe that the government should take the lead to set good examples. In the past, for a period of time, the government was willing to take the lead to employ PWDs and deploy them to different bureaus and departments. So the government should take the lead to encourage society and all sectors of the community and stakeholders to employ PWDs. For those with hearing impairment and the deaf, there are quite a number of them working in the government, and they're above 36 years old. But there are now very, very few such PWDs at the age of below 36. Is it that the government is unwilling to take the lead to employ those with hearing impairment and deafness, then society could do no better. There are support programs for the PWDs, like the Sunny Way. However, they are not that effective. For the deaf and those with hearing impairment and other PWDs, they face unemployment problems, discrimination in the workplace, etc., etc. So the government should take the lead to improve its policies. Our association strongly believes that the deaf can still work. We appreciate the skills and talents of the deaf and those with hearing impairment. We believe that they can self-rehabilitate themselves. We would like society to give them more opportunities to work in workplaces. Now, 40 to 50% of our members are deaf or with hearing impairment. They live very happily with our able-bodied staff members. However, the government was unwilling to employ more people with deafness or hearing impairment. So should the government not encourage the employing of more PWDs? Otherwise, our supportive programs will be futile, and the financial burden on the government and the surveillance sector thus incurred would be heavy. In 2007-08, the CE's policy address encourage young people with disabilities to work in various workplaces, and 1,000 quotas were allocated to young persons with disabilities so that they can make use of their talents and skills. Next, Mr. Wong Wai-kwok from Chung-kai Bank 患者就業關注組. Thank you, Chairman. This time I'll target the CSB. In fact, all along it's very difficult for PWDs to find jobs in the job market. Only very few scrupulous employers and scrupulous social enterprises are willing to employ PWDs. Every time when we sought help from the government, the CSB said that under the principle of fairness, all candidates had to successfully pass the recruitment exercises. In fact, that's not fair to PWDs. PWDs have less job opportunities, so they have very little or zero working experience. And sometimes their abilities and efficiency might be less than able-bodied candidates. So every year only about 30 PWDs could successfully join the civil service and enter the government. Therefore, the CSB should model on social enterprises which allocate certain places for PWDs. Some enterprises like Disneyland and McDonald's also reserved places for PWD so that they can make use of their skills and talents. If the CSB is willing to learn from them, then more PWDs can be employed. Mr. C.Y. Leung, during his election, promised to increase the ratio of PWDs among civil servants. I wonder whether the CSB had talked to C.Y. Leung. If so, why are you not employing more PWDs? Finally, I'd like to tell you my personal experience. About 20 years ago, as I was disabled, people told my mother that I had become a useless person. My mother was very frustrated. She cried. I tried to find a job, and after half a year's time, a company was willing to give me a chance, and I worked for 10 years there. How important that job was to me. My mother became very happy. She no longer had to hear the very bad words from others. Besides, my girlfriend saw a prospect to form a family with me, so she was willing to form a family with me. So much for my remarks. I hope that the CSB can strongly consider our views and suggestions. Finally, I suggest that the CSB open extra places for PWDs and keep the ratio of 2% for PWDs. Thank you, Mr. Wong. Next, Mr. Yip Wing, representative of Labour Party. Thank you, Chairman. I'm Yip Wing from Labour Party. In the past 10 years, the administration advocated for employing more PWDs. But in actual fact, did the government really attain the 2% employment rate for PWDs in the government? Nobody knows. But earlier this year, from the data produced by the CSB, in 2012, only 50 PWDs were employed. And now there are 3,391 disabled civil servants, most from the police, 625 of them. Now let me tell you how to do the calculation. Given 3,391 PWD civil servants with 50 new recruits this year, it will take 67.82 years to recruit so many people. And just on the 5th of July, a number of PWD organizations convened a meeting to discuss the issue. In front of the EOC and other departments, Ms. Chan from the CSB said that the government would not ask PWDs to leave the civil service. That's tantamount to admitting that aging and other problems would be included in the 2% target. Even the EOC representative then said that the situation was worse than before 1997. If the government does not take the lead to employ PWDs, how can it encourage large corporations to recruit PWDs? So that 2% should be a hard and fast indicator for employing PWDs. Besides, there should be tax concessions for those 88% of PWDs who had no jobs, so that it's easier for them to find jobs and can make use of their skills and talents. To encourage employing PWDs should not stop at advertisements placed on buses. I hope that the government will turn back and really assist the PWDs. Don't cheat. Don't tell us that the police employed 625 PWDs. Some of them are actually in civilian posts, so don't cheat people anymore. So much for my remarks. Thank you. Next, the Hong Kong Council of Social Service, Ms. Maureen Tam, convener of Network on Services for Persons with Visual Impairment. Good morning, Chairman, members and government representatives. Our network liaises with 13 NGOs working on the visually impaired. We also liaise with the government. All along, the government supports the employment of PWDs in the civil service. But starting from 2006, for the employment of the visually impaired, there had been a drop of 11.7% in the employment of the visually impaired in the civil servants. That had dropped from 462 to 283. We welcome this discussion in this panel. We would like to raise common concerns for the visually impaired such that the government will actively follow up on them. Our concerns are as follows. Number one, in the past 5 years, how many visually impaired candidates were there for civil service jobs, and what about their successful rate? Number two, for visually impaired civil servants, after their departure from the civil service, had visually impaired candidates be recruited to replace them? Was the success rate high, What are the details? We would like to know them. Number 3, in promoting the use of IT, was appropriate training provided to the visually impaired civil servants so as to enhance their working abilities in their new tasks. Number 4, the visually impaired only need very simple equipment to satisfy the requirements of civil service jobs. We expect the CSB to actively introduce to various government bureaus and departments the supportive equipment required by the visually impaired, such that the visually impaired can personally share their working experience, so as to encourage bureaus and departments to employ the visually impaired. In the past, the government has adopted a positive attitude in employing the visually impaired, but the employment rate for such PWDs was on the low side. So we'd like bureaus and departments to employ more visually impaired to encourage them to integrate into society. Thank you, Ms. Tan. Next, Mr. Mo Yun Kwan from the Rehabilitation Alliance Hong Kong. Thank you. In recent years, we observed that the government had adopted a number of positive measures to encourage the employment of PWDs. However, if the government does not take the lead to employ PWDs, it will be very difficult to convince other employers to employ PWDs. So it's necessary for the government to take the lead to introduce a placement system for PWDs. After so many years, the target rate is only 2%. But how many PWDs have been employed by bureaus and departments, rehabilitation organizations never know. If we can have a quota system, then we would like the target rate to be increased from 2% to 5%. For the EOC, its employment rate for PWD stands at 5%. We hope that the system will not just cover the government, but also subvented organizations. For both the public and subvented sectors, all organizations should make public their rate of employment of PWDs. And then to encourage NGOs to employ PWDs in the procurement of services and products. If a certain organization employs a certain level of PWDs, then the enterprises should give an extra scores.
And we also want the CSB to stretch its brains. Many disabled persons have potential not yet tapped. For instance, the CSB can consider some positions such as reception using sign language, and also coordinator of barrier-free access. Well, perhaps they can be new job opportunities for the disabled. Thank you. Mr. Johnny Lee from Concord Mutual Aid Club Alliance. Good afternoon. Our alliance is a self-help group made up of ex-mental patients. Employment is one of the most important aspects when it comes to the rehabilitation of mental illness. Through working, we can reestablish our value, rebuild our self-esteem. However, many of us have encountered great difficulties in job seeking. If we cannot improve our employability or our job opportunities in the market, then I think we're wasting valuable time and resources. So we urge government departments, public and subvented organizations to have a setup, to have an indicator for employment of disabled persons. There should be recruitment objectives every year for employment of the disabled. We should not calculate employees that became disabled or that have suffered from long-term illness into the statistics. Well, we need job opportunities and experience. The government should safeguard our job opportunities. The government and public organizations should have a certain ratio for the employment of disabled employees so as to encourage the private sector to follow. And thirdly, we hope that the administration can formulate policies for all public and private organizations contractors. This indicator can be used as a reference so that the bid will not just go to the lowest, or the contract will not just go to a lowest bid. For contractors that are willing to employ disabled persons, they should be given some priority. Thank you. Thank you, Mr. Lee. Mr. Danny Chen from Hong Kong Society for the Blind. Good morning, Chairman. Our Career Support and Development Center conducted a survey in between July and August last year. We successfully surveyed 133 members. And according to our survey and our daily contact with persons suffering from visual impairment, we have 6 recommendations for government departments to consider. First, please pay attention to the recommendations by the relevant members of the community. There should be a indicator for employment of disabled persons, and then the results should be made public every year. For reference, for departments and organizations that are able to meet the targets, they should be commended so that we can help people suffering from visual impairment to be employed. And the the deficiencies of disabled candidates of civil service jobs should be announced so that the disabled can then enhance their skills and enhance their chances of being employed. And according to our survey, many people with visual impairment are interested in social welfare work. So we suggest that the administration provide talks for them so that they know points to note when they apply for civil service or social worker jobs, so that they can be better prepared and they can stand a higher chance. And there should be seminars for already employed disabled persons, and also for those in school and receiving training. The parents should also be covered. The government should take the lead to provide internship program so that the visually impaired can work as trainees at government departments so that they can acquire the necessary knowledge, skills, and ability to be employed in the future. We are now in an information age. Many people who have visual impairment do not have sufficient IT skills, so there should be sufficient training for them to upgrade their skills in this regard. The government should also deploy resources to assist organizations to have more resources to train people with the potential to become a master. Thank you. Dr. Robert Hansen.
It's on disability, lighting and visual impairment. Firstly, the Oxford English Dictionary defines disability as the thing or lack of thing that prevents one from doing something. I've been looking at legislation globally on disability, lighting and visual impairment, and there's a trend that disability and equality legislation and resultant court cases in Great Britain and across the globe are making it increasingly clear that all employers have a duty to make reasonable adjustments in the workplace to avoid any disabled person, for whatever reason, from being at a disadvantage to a non-disabled person. Now, I want to talk about lighting because the government, in actually promoting certain types of light, has actually been creating disability. You may be aware of this consultation document, particularly members that sit on the Environment Panel, and it's been promoting compact fluorescent lights and LED lighting in the workplace. The problem is, we know from research across the European Union that 1 in 30 people are now rendered disabled under this type of lighting, because CFL and LED lighting is not a substitute for the traditional incandescent light bulb. Just a straight glance at the light spectrum tells you straight away: natural light, incandescent light, fluorescent light, and LED light. It's totally different. And for people with eye difficulties like myself, we can't distinguish colour under lighting, we're drained of energy, and it stops you actually from going to work and living a normal working life just because of lighting. And what government should be doing is not increasing disability by promoting this type of lighting. Rather, they should be reducing disability by giving people the choice of light bulb at work and actually telling the truth about the problems of CFL and LED lighting and not hiding it for other policy considerations. Now, employment tribunals have ruled that employers have to make reasonable adjustments to provide lighting that does not cause otherwise able-bodied people to become a disabled person. And in reaching this conclusion across Great Britain, employment tribunals have held the following: light sensitivity is a disability, and it falls well within equality and disability legislation. Secondly, the light from CFL and LED lighting is completely different than light from incandescent lighting. And the number of CFL and LED lights do cause able-bodied people to become disabled-bodied people. The Optometrists Association has commented on this, and it recommends fully that employees should be given a choice of light in the workplace to avoid being rendered disabled, and I hope that employers will recognise this and give employees a choice of lighting in the workplace. Thank you.
Thank you, Dr. Hanson.
Thank you, Mr. Danny Chen. Dr. Hanson. Next, we have Mr. Zhong Chen-yao from the Alliance to fight for work opportunities and employment quota for the disabled. Thank you. More than a dozen of these associations have come together to form this alliance, hoping that we can have more job opportunities for the disabled, and there can be in place an employment quota for the disabled. The government, even the business sector, have expressed reservations about this, saying that the EU has some negative comments on this policy. However, we believe that this is a very effective way, a very effective confirmative action to promote equal opportunities, because all along, the employment opportunities for the disabled have been too low, and we want some indicators to be set up, not just for the government, but subvented organizations, public bodies, and organizations where the public have shareholdings should be covered. And this should also involve the government's procurement policy and its outsourcing policies. This is already a government-accepted policy, and through these means, I think it is common for government to advance or further their policies. We have seen successful examples in the US and other countries, and gradually we decide whether an employment quota for the disabled should be set up. In para 7 of the paper, in para 7 of the paper provided by the government, dated the 17th of June, it is said that it is not appropriate for the government, or according to the Equal Opportunities Commission, it is not appropriate to have such a quota set up. Now, in the past, the administration changed its attitude after our criticism. So I think the government should follow its previous position instead of its later position. And then there is also another paper by the government. Over 700 respondents from 65 organizations have responded to the government's interview. I don't think the government should be satisfied with this, because the government is subventing more than that number of subvented organizations. Why is it happy with such a small number of responses? And the government has also supports also over 400 schools, not including tertiary institutions. But what about TDC and MTRC? They're important public bodies funded by the government. So the government should follow up in these areas. I have a lot more to say. I'll provide written submission later. Thank you. Mr. Wen. From the Hong Kong Joint Council for People with Disability. Thank you. All along, we have been promoting and fighting for the welfare of the disabled. First, regarding the unemployment rate of the disabled, it has always been high. The government has not announced the actual unemployment rate of the disabled, but we know that their wages have always been low. According to a survey in 2008, a thematic report, the unemployment rate of the disabled was 5.9 times that of their able-bodied counterparts. Whereas, according to the OECD, it should just be about 2%. So the figure in Hong Kong is very high. And then the employment rate for those between 15 and 59 was only 33%, whereas the corresponding figure for the able-bodied counterpart was 47%. And in OECD, the overall employment rate for the disabled was 60%. So Hong Kong is lagged behind other developed countries. According to the Meta Report number 48, the median income was just $6,800, less than 70% of the able-bodied counterpart. And for those earning less than $1,500 per month, they accounted for 40% of the total population or disabled population. And according to the administration's paper, a mandatory quota was not going to help. We have tried to take reference from Taiwan's experience, and we believe such a quota will be useful. Taiwan introduced a quota system in 1990 for the employment of the disabled. For public and private organizations employing over 100 employees, they must also employ at least 1%. They must have at least 1% of their employees being disabled persons. And then in 2009, Taiwan adjusted that figure for public and private, or for government and public bodies employing over 34 34 employees, at least 3% of them have to be disabled. And for private organizations, if they employ more than 67, then at least 1% of the employees should be disabled. So according to data from Taiwan in December 2012, 69,000 odd disabled persons were in employment. And according to the government's paper, too few organizations have got that data, and they were not mandatory. Only 65% of them could provide information on the employment of the disabled. We're now trying to ask the administration to sign a charter to safeguard the employment of the disabled. I urge members to support us. Thank you. Mr. Andy Chiu from the Association for People Suffering from Mediterranean Anemia. Thank you. Of thalassemia. Thank you. We have a few questions for the administration. First, I hope the SCS can attend our summit to be held on the 24th of August on the employment for the disabled. And I think for a long time, the CSB is not too concerned about our plight, and every time they just send Ms. Chen Yue Sim to our seminars. We're not happy to that. And we want the government to lower the threshold for employment of persons with disabled. Why should we have to have received tertiary education and with years of experience before we can be engaged for clerical tasks such as folding of posters? While the government is trying to recruit civil servants, they have refused to renew our contracts. They've even sacked disabled employees. Take the ILD and EPD and other government department example, they are doing that. And why must the government employ contract staff and temporary staff? We only offer 1 month, 3 months, or 1 year contracts.
So I think we are in a hopeless situation. Also, why is it that PWDs working in government departments don't have any prospects of promotion or transfer to other departments? Why is it the government is chopping up one job into 2 parts and asking part-time people to work asking people to work on a part-time basis? And people don't like employing the disabled. They say that we are lack of skills, and they don't want to renew contracts with us. What kind of thinking is that? What kind of mindset is that? So I hope the CSB and the selective placement division of the LD can work better together and collaborate to help PWDs seek employment. Lastly, I hope that the government can employ among its staff members 2% of its staff members, filling 2% of the posts, PWDs. All right, Alliance for Employment of PWD, Mr. Chen Chen-yu. And I think the PWDs have a difficult situation. PWDs are not necessarily come with low education level. We don't any mercy from you. We want a respectable job. We hope that the government can employ PWDs. Mr. C.Y. Leung, in his policy address, said that he would promote employment for PWDs. But have these policies been implemented in the past year? Can you undertake to do more? So we PWDs hope to be given more employment opportunities. Then we hope that the CE Leung Chen-ying can deliver his promise and provide more jobs for the PWDs. Thank you, Mr. Chan. You're finished, right? Thank you very much. Next is from Summit for Employment of PWDs and Chronically Ill, Mr. Han Yong-shen. Chairman, members, good afternoon. Many people have spoken on the issue. I hope Mr. Tang and Mr. Leung of the Labour and Welfare Bureau can take heed of our views and talk to us more so that they can better understand our demands. We should be your partner, and we should work better with you so that we can build a more harmonious society. The 2 secretaries do not attach importance to the needs of the chronically ill. They have not been able to do much for us. Say for the 2% employment target for PWDs, they weren't able to achieve that target. The 625 PWDs are employed in the police force. But that's a small number, and a lot of PWDs can't get into the police force to work. Secondly, I strongly urge you to lower the entry threshold for jobs in the government. In terms of qualifications, experience, and skills, you are setting very high standards. Even for a clerk, a junior clerk, you need him to attain Form 5. But for the chronically ill, many of us haven't been able to achieve that educational level. All right, for some PWDs, they may have only a few fingers, and you are still requiring them to type 30 words per minute. So they can't take on those kind of job. It's the demands are too difficult and too high for them. I think you should lower your threshold. Thirdly, on the selection interviews and tests, I hope that you would also lower your threshold and give more opportunities to the chronically ill. Fourthly, I hope that you would shelve your contractor system for PWDs in employment. Just like what a friend said here, he's been able to stay on his job for, say, 10 to 20 years. So if you are hiring a PWDs or a chronically ill on a contract basis, and it will give him a lot of difficulties because he would find it hard to find another job. Thank you, Mr. Han. Hong Kong Society for the Deaf, Ms. Sarah Lee. Madam Chair, good afternoon. I am a severely hearing impaired person. Our work is to help the hearing impaired, and they have a high unemployment rate. There are some 360,000 PWDs in Hong Kong, excluding the mentally retarded, and only 1.5% or 50% of them are employed, and that compares unfavorably to the normal 60% employment rate in Hong Kong population as a whole. So I hope that the government should draw up measures to provide job opportunities for the PWDs. We have been discussing the employment quota system for PWDs for some 30 years, and the government has not been responding positively to that. And they are not willing to legislate on a quota system, and that compares unfavorably to other countries, say in countries like Germany, France, and even China have legislated to protect to provide job opportunities for PWDs. They have set a target of 1.5%. And if enterprises don't achieve their target, they have to pay a certain sum to the government. I think we should legislate, and we should start with the government and public bodies. They can start with a 2% first, and then raise it gradually. I think what's most important is that the government is willing to legislate and come up with a timetable. Secondly, the government and public bodies may have to purchase services and products. And when they do such purchases, they should give priority to social enterprises. And also suppliers who employ PWDs or self-employed PWDs who provide such services. I think it will help a lot. Third, the government may provide a wide range of services, and some of them are outsourced to outside contractors. So in such outsourcing contracts, the government should add in conditions to require the contractors to employ a certain percentage of PWDs. In 2010, the government contracted out a 5,121 contracts worth $52 billion. And I think if we do it the way I propose, that will help a lot. Fourthly, we think that tax concessions should be provided to companies employing PWDs. The more PWDs the employer, the more concessions they should be able to enjoy. That will encourage enterprises to employ more PWDs. And then Ms. Lam Ka-yan, I think the government is not implementing effective measures to help people from seeking employment, PWDs. I'm a hearing impaired person. I don't have a lot of job opportunities, and I'm very unhappy. And the jobs I managed to get are contractor jobs. And some employers may not know the needs of the enterprises. I think the selective placement division of LD should do a better job and should try to understand more about the job needed by the hearing impaired. And sometimes the jobs may be cancelled, and that would deal a blow to the job seekers, the PWD job seekers. And the government says that it is trying to do its best, but then the reality is not really like that. For some civilian posts, some hearing impaired employees may have to work with duties like taking telephone calls, and that creates a lot of convenience for them, and they find it hard to follow up on those calls. And then they may have to work with their other colleagues, and they may have to relay the messages to the able-bodied counterparts in the department. And then this particular employee has asked for a transfer of their post, and then it took a year before she was transferred to another post. I think the government should provide an appropriate job to the hearing impaired, and I think the government should also shorten the time for making transfer of jobs for these unemployed or for this hearing impaired employee. I hope that the government will also lengthen the employment period for the PWDs. The government should take care of the needs of the jobs and should try to lengthen the employment period for the PWDs and should not employ them on contract basis, because it will deal a heavy blow to the confidence of the PWDs. And I think the support measures provided are not enough. I think the government should provide more job opportunities. The government should try to help in enhancing the job opportunities for PWDs, and the government is making available a fund for government departments to apply to and make adjustments in the workplace for government departments. But a lot of government departments don't know about that, and a lot of PWDs don't know about that. So these measures are not of much help to the PWDs. Thank you, Ms. Lam. Next one, Mr. Aoyang Xiulang. I'm a hearing impaired person. I have difficulties in hearing and speaking. When we apply for government jobs, what kind of difficulties do we encounter? The government looks at your skills, qualifications, experience in employing PWDs. They also look at your interview skills, whether you speak fluently, eloquently, whether you are what you say is audible and comprehensible, and so on and so forth. So the government takes heed of all these factors. So for PWDs, they are subject to the same set of consideration. It seems fair on the surface, but then I want to raise 2 points. I want to say that the hearing impaired have the same skill sets as able bodies. They have the professional knowledge and skills. They aren't much different from the able bodies. Well, but then when it comes to interview skills, the hearing impaired are at a disadvantage because they will gain 0 mark in their interviews. They won't be able to compete with the able-bodied. So my question is this. So this is not a fair set of standards because I speak not so eloquently, so I gain 0 mark, score 0 mark in an interview. So even the hearing impaired may have good job skills. They gain 0 mark in an interview. They will never get a job. So I have this question for the CSB. Would you be adjusting your scoring system based on the hearing impairment of the hearing impaired? Also, most of the PWDs working in the government are at the junior rank or in general grades. I am a university graduate. I want to join the middle or senior ranks. But then there are so many competitors. So if what I said is true, I will never be able to join or work at the middle or senior ranks. It's not that I don't have the job capability. It's just that I perform poorly in job interviews. That's not fair. So much. Well, that's what I want to say. All right, next. Mr. Wong Chun-han from Hong Kong Blind Union. Thank you, Madam Chair. Our union has distributed a submission to members. I'm not going to repeat the points made there, but want to highlight some very strange phenomenon here. The first one is the visually impaired. With the aid of some computer systems, they've been able to attain a high level of education. Well, the number of visually impaired people who have studied to university level have increased so much. Now, with all the computer aids and technological aids, the visually impaired has good skills, job skills. Well, they are suitable to be employed for more jobs now than in the past. But what is weird is that within the civil service, fewer and fewer civil servants are visually impaired. Don't you think that is very strange? Our educational level has climbed, whereas the number employed is getting less. Now, based on the number 48 thematic report, the visually impaired takes up 2% of the overall total workforce in the civil service. But then the proportion is not that in the number of new recruits. Don't you think that is very strange? The secretary or your colleagues or LegCo members, please respond to my question. Do you think that given the necessary support measures, visually impaired can perform as well as their normal counterparts? I think this is a mindset that we should all have. Do you agree that the PWDs or visually impaired can perform as well as their able-bodied counterparts with the necessary support measures. If the government doesn't want to implement facilitating measures for the PWDs, then I think we're wasting our time having all these discussions here today. Can the Secretary respond to my point? All right. The Fourth Rod Caucus, Mr. Siu Yat-chen next. Thank you, Madam Chair. The unemployment situation of PWDs is really serious. Unemployment rate is 88%. The government claims that it promotes employment of PWDs. But then government statistics show that the government is the biggest employer. It doesn't take the lead in employing PWDs. And the figures are dropping instead. The 2% target, is there a problem with that target? I think the Fourth Right Caucus doesn't take the lead in employing PWDs. If that is the case, it's hard for it to convince other private organizations to follow the lead. Now, in the SPD of LD, in the cases handled from 2004 and to 2012, the number of cases referred has dropped from 3,800 to 1,900. So the drop is 48%. And the number of cases in 2004 is 177, and it's 31 in 2012, a drop of 82%. Success rate 4.1%. In 2012, is dropped to 1.5%, and that represents a fall of 66.6%. Some groups told us that fewer people are getting into the government in the past few years. From 2010 to 2012 is 41, 40, and 50 respectively for these 3 years. Among the 3,391 PWD civil servants in Hong Kong, well, based on the percentage I mentioned just now, it would take 68 years to employ 3,000 PWD civil servants.
Were civil servants who were originally PWDs covered? I don't have that many statistics. From 2008 to 2012, PWD for the visually impaired and the visually impaired is a drop of 5% and 7%. For the visuals, a slight rise of 0.4%. Visual impairment and other impairment, ex-mentally ill persons, a rise of 6%. Perhaps I can submit my written comments to you after the meeting. Last deputation, VTV disabled web TV. Mr. Kwang Chung-on. Thank you, Chairman. I'm Kwang Chung-on. I'd like to mention some specific conditions. Whether or not the government will provide resources for studies, you might have heard about policy studies on work style adjustments. There are concrete examples, both locally and overseas, to experiment on the actual circumstances. After work style adjustments, certain units like libraries could actually have employed a lot more PWDs. They could even be manned by PWDs in the majority. At present, only a few PWDs are employed in each organization. If we can attain that, then we can increase the percentage of PWDs employed. So the government should carry out policy studies on work style adjustments. I believe that work style adjustments can assist PWDs to make full use of their skills and talents, and society will understand them more. As for subvented organizations, will the government note the employment situation for PWDs? According to LWB papers, among the NGOs, 139 responded to a questionnaire survey. Only 11 had set non-mandatory guidelines on the employment of PWDs. So it's only 4.5% of the total figure. That indicates that the attitude of NGOs in employing PWDs is really very insensitive and non-caring. The government has the responsibility to formulate policies on employing PWDs. Unless the government does not want to employ PWDs. Finally, I'd like to share with you my personal experience. I did work in the efficiency unit of the government. As a visually impaired, I believe that job very much suits the visually impaired. However, as far as I know, last year, organizations on visual impairment invited tenant members to visit that center in the efficiency unit. Applications were submitted for jobs, but for the tenant new recruits, only one was visually impaired. As far as I know, the visually impaired are very suitable for that job. So I'd like to know the priority for employing PWDs in that unit. May I have some responses from the administration? The deputations have already finished speaking. 5 members would like to speak. Tan Ka-pyu, Lee Chak-yan, Emily Lau, Fernando Chung, and Leung Kwok-hung. Secretary, would you like to listen to members first before responding? All right, 3 minutes each. You ask questions first, and the secretary will answer both deputations and members in one go. Mr. Tan Ka-pyu, understand the feelings of the deputations. Sorry for keeping you waiting because of this long agenda. In the government's paper, in paragraph 11, it said that 94 persons were given an employment certificate. That is 3%. The government wants to tell us that sufficient training has been provided. In fact, the government is playing with words and figures. In the past 5 years, among the 29,683 civil servants recruited, only 172 were PWDs, just 0.5%. In fact, 422 PWDs should have been employed instead. You put 3% in a bracket, indicating that the ratio is problematic. And if these civil servants became PWDs only after recruitment, that indicates that there are problems with your conditions of service. You said that priority would be given to PWDs in interviews. But just now an official already said that just now a deputation said that no priority was given in interviews. Will you make adjustments? There are 2 questions. First of all, for short-term jobs, why is it that they're so short as 1 month, 2 months, or 3 months? Are they tailor-made for PWDs, as they said today? If so, is it discrimination? We'll wait further questions first, due to time constraint. Mr. Lee Chak-yan, I would like to have an immediate reply. First of all, I'd like to thank the deputations for attending this meeting. I think they all put forth one very important viewpoint. That is, the government must take the lead Otherwise, NGOs and all the more private companies would not follow. I think the government is playing magic. It is trying to play with figures. Look at Annex A. I've done some calculation. The number of PWD civil servants leaving the civil service in the past 10 years, 1,694. 178 recruited in 10 years. That means net departure, 1516. Incumbent PWD civil servants always stands at 3,000 odd. How is the government playing this magic? Net growth 1,516, but you always give us a figure of 3,000 odd. So, Chairman, I'd like to have the reply. I think the Secretary has heard you. He'll give you an answer in one go. I want an immediate reply because I have 3 minutes. So within 3 minutes, Secretary, please answer that question. 1 minute for you. Just on Lee Cheuk-yan's question. I'll defer to my colleague. As far as figures are concerned, as we say in our paper, the figures therein are statistical figures. That means that colleague declared himself a PWD or the department concerned had mastered the information. At present, we cannot rely on each and every colleague to mandatorily inform departments concerned that there are PWDs. So these are statistical figures. As for the trends of the statistics, we can only look at the actual figures. So these figures include those civil servants who became PWDs after recruitment. That's why some deputations said that you are playing tricks. So you have included industrial injury cases. These civil servants became PWDs after recruitment. Well, to put it in simple terms, you've not recruited PWDs. You relied on civil servants becoming PWDs after recruitment. Oh, the target is 2%. Say who is chronically ill, who sustains industrial injury. You include them. Oh, that's really very exaggerating. Ms. Emily Lau. Thank you, Chairman. I'd like to thank the deputations for attending this LegCo meeting. My concern is not just about PWDs employed by the government. I'd like the Secretary to give us more statistics on PWDs recruited by subvented organizations and the private sector. The figures are quite disappointing. As the deputations requested, the government should set a good example. Now we're neither here nor there. Today, so many of them have come. I think they've told us their difficulties in seeking jobs, not just in the government. They mentioned difficulties facing the PWDs. The government and the subvented sector should do more. In fact, for a long time, we've heard that there are a lot of vacancies in the government. We're always told in LegCo that be it service industries or whatnot, it's very difficult to recruit people. Should the government not help by providing more training? For example, conferences should be convened to allow them to know how they should prepare themselves for interviews. Be it the Disneyland or Ocean Park, the hospital authority has 3,000 of vacancies, but only one for PWD. I mean for airport authority, not hospital authority. Well, Secretary, you should give us a reply by telling us what the government will do. You have rejected this quota system. So how are you going to mobilize the employment of PWDs? Every year they come out to say that the figures are very bad. So how can you assist them to do better in future? Can you have internship programs? Can you provide more support to the students? You've grasped so much resources. Not all political parties are represented here, but I believe all councillors and political parties would like you to inject more resources and effort into this. On the one hand, you say that there are a number of civil service vacancies. At the same time, so many people say that they're unemployed. Given these statistics, the government should take the lead. Does Hong Kong fare worse than other jurisdictions? We always say that Hong Kong is very much developed, but we fare so poor in this regard. Can I have a reply in a moment? Dr. Fernando Cheung. Just now, Mr. Lee Chut-yan already uncovered the deceiving figures there. 3,000 odd, as they quoted here, include those civil servants who became PWDs after recruitment. Now, overall speaking, in the civil service, you have 2% of civil servants being PWDs. In fact, they were not PWDs originally. They worked so hard, they were made to work so hard that they became PWDs after recruitment. And you're able to give us these figures. In the past few years, the number of PWDs employed has increased, but still, they account for just 0.5% of the overall number. So how can you mobilize the employment of PWDs? 2 points raised by the deputations just now are worthy of our concern. A few deputations mentioned that the government now use short-term contracts to employ people. You separate one job into 2-3-month contracts. Sometimes the contract lasted a month only. And then you said that you claimed that you had employed PWDs. Are you trying to create these figures yourself? Please tell us. Secondly, in the LWB's paper, as our colleagues pointed out, the number of referrals to the civil service had tremendously dropped. I'd like the SPD to tell us why, in the past few years, the number of referrals, PWD referrals, had dropped so tremendously. Do you want to give an answer in the remaining 1 minute? I prefer an overall reply. All right, last speaker, Mr. Leung Kwok-hong. Yesterday, I went on a ride with my adopted daughter. Sorry, we've exceeded the 15 extra minutes, so I'll extend the meeting by another 15 minutes. Yesterday, I went on a ride with my adopted daughter, and we played a computer game. She said that that game or that person was useless. I told her that she might be more able than I in certain respects, but not in all respects. A PWD may sustain disability because of various occurrences, such that that person is a bit different from the able-bodied persons. So we have to do something to assist the PWDs in their workplaces. If you don't have a budget for that, there's nothing we can do. If a person is physically handicapped, if he is not served by barrier-free accesses, then there's no way he can work properly. Your budget must allow bureaus and departments to be able to employ 2% of PWDs. Otherwise, bureaus and departments are not prepared to cut their own budget in order to recruit PWDs. I think you are PWDs. You're mentally disabled. Your mindset is disabled and handicapped. Now that you're doing this just because other people are forcing you to do it, you're disinterested in it. Why you are creating these figures? You want to produce an accumulative effect. Secondly, your civil servants become disabled after recruitment. You provide me with these figures. You don't explain in these figures how these civil servants have become disabled, in what way they became disabled, etc., etc. There are no details in these figures. Try to claim a disability allowance. You have to do more. Then you may refuse or refrain from creating these figures. If many other colleagues have to be employed to assist a PWD, you won't be willing to do that. That's why you have to create these figures. Why? Because the government is suffering from an illness. That is the illness of telling lies. The CE has also been telling lies. So, Mr. Tang, you don't have to answer me. Spend your time on answering others. Thank you, Mr. Leung. We have 10 more minutes to go. Mr. Tang, would you please answer all the issues in one go?
I'll try my best to respond to all the questions. There's the mention of the number of disabled civil servants. Well, we have already made open such figures, but we will see whether we can provide further information. We'll continue to improve on these figures, and we'll also publish the relevant data. Regarding indicators and quota, as I've explained, we have studied this in great details. The world trend is to provide equal opportunities for the disabled as far as possible so that they can secure jobs on the basis of their ability, not because of their disability. I think we should move towards this direction and provide facilitating measures as far as possible to encourage them to work for the government. And I believe that this is more positive approach to achieve integration. To assist PWDs to apply for government jobs, usually we do not require any declaration. Declaration can be done on a voluntary basis. We believe that some candidates have chosen not to make that declaration or not to state that in the application. But once a declaration has been made, there will be no shortlisting. The candidate will certainly be invited to an interview. And we will offer facilitating measures, for instance, to assist them to attend interviews, to take the relevant recruitment tests, so on and so forth. And we also have priority arrangements at interviews after seeking legal advice. When we believe that suitable candidates are suitable, then we divide them into 3 categories: those who are suitable, and marginally suitable, and not suitable at all. So if colleagues, or rather if a disabled candidate is included in any of the 3 groups, they will automatically take up the top priority in that particular group. And I think we should not just look at the number of candidates, but the success rate compared with about 3% of the qualified disabled candidates were successful, higher than the 1% in the past. I hope members understand that civil service jobs are very competitive nowadays. Relatively speaking, PWDs have enjoyed a higher chance of success when it comes to the appointments to civil service jobs. We will enhance internship or job attachment opportunities for PWDs in addition to the Sunny Way program. We'll see whether other programs can be provided so that they can get to understand government jobs more, so that they will have higher chance of success when they apply for jobs in the future. We agree that sometimes it's such a change of mentality. We hope that departments can change their mentality. When PWDs can fit the requirement of the jobs, they should be given priority as far as possible. We will discuss with our departments. And if there are any procedures that can provide additional support, we are happy to do that. We have got a fund to help successful candidates to buy aids and assistive devices to assist their job. As for short-term jobs, usually short-term posts would depend on the requirements of the job, and short-term contracts will be offered if the job itself so demands. This is not restricted to PWDs, and if other conditions are right, we will employ candidates on civil service terms. A few years ago, there was a freeze in civil service recruitment, and we have seen a gradual increase in the number of PWD new recruits in recent years. Some members asked why there were fewer referrals from the selective placement division. My colleague can supplement, but I believe it's because many PWDs can apply to the government direct, for instance, online, so they don't necessarily have to go through the Labor Department. So it all depends on the number of applicants and the job vacancies for that year. As regards how we can promote the employment of disabled persons in subvented organizations, as mentioned by some deputations, the Labor and Welfare Bureau is now promoting a charter for the employment of PWDs. We want subvented and aid organizations to participate in the charter and to promote the employment of PWDs. I don't know whether my colleagues have anything to add. Any supplement? Yes, the Labor Department can supplement. Our existing mechanism is that PWDs don't have to apply for government jobs through the LD. So in recent years, many of them apply directly and they can submit their application online. That's one of the reasons why referrals have dropped. And it also depends on the number of vacancies and the job requirements. For instance, last year, there were a few civil service posts keenly sought after. So there were referrals. Last year it was 1,971, and the year before 1,800 odd. So we also refer candidates to private sector jobs as well. So we have made more referrals to the private sector because many PWDs would like to try to work in the private sector. In 2012, we have made 13,028 jobs to the private sector. So it's entirely up to PWDs. They may opt for private sector jobs or government jobs. Any more? As far as the LWB is concerned, we've always encouraged subvented organizations to implement measures to promote employment of PWDs. For instance, they should have the right policies and procedures in place, and they should give priority to services and products offered by PWDs. According to number 48 of the CNSD, the overall employment rate of PWDs is 10%, 2.5 times that of their able-bodied counterparts. So we maintain an open mind. Regarding additional support to PWDs for their employment, through the SWD, VTC, and YAB, we're providing the services needed by PWDs, such as vocational training and job matching and follow-up services. We've also increased funding to enhance subsidies to various programs to encourage employers to employ more PWDs. We also want to encourage NGOs to employ PWDs. We have asked NGOs to start small enterprises, and the government will provide them with a small startup fund to get the business going and running. And so far, we have assisted about 70 to 80 enterprises to start operation. Yes, and also assistance provided to persons with disabilities within the government. That is important. We have a fund to help employers to improve their workplace, and each employer can apply for $20,000 to do that. We want to continue to encourage NGOs and other organizations to continue to employ PWDs. Thank you, government departments, for your response. Dr. Fernando Zhang. I think that the departments are not committed at all. They said that is among the top priorities to promote employment of the disabled, and yet they only have a charter to ask organizations to take part, and CSB is just giving us data to paint a rosy picture. While I'm not a member of this panel, I cannot move any motion. I hope this panel can cooperate with other panels to follow up this matter. I fail to see how officials here can help the employment of PWDs. I hope that they can have an employment indicator and in procurement of services, and they should also promote the employment of PWDs in subvented organizations and NGOs. They must double their efforts. I think you should follow up at Welfare Services Panel. The employment of PWDs in the civil service is just part of the work of the CSB. I agree with Dr. Zhang. I hope Mr. Zhang understand that we're going into summer recess quite soon. After the summer, you have to come back and give us an update. Chairman, please put this on our list of outstanding items. And in 2014, please come back and tell us the latest statistics, and do not just make up figures to make it look good. No, we disagree that we have make up the figures. But of course, we will see how effective these measures are after 1 year. Once again, I'd like to thank deputations and individuals for attending our meeting. It's already 1:30. I declare the meeting closed. And thank you, officials from the Bureau and their colleagues. Thank you.